All right, everyone, let's go ahead and get back to our seats. The item that we're currently on is proposed Chapter 30 Child Welfare Code Amendment. This section is open to the public. So in short, the Board of Directors is considering changing Chapter 30 to include a provision to where we could allow long-term abandonment to be grounds for termination. So Ryan, if you want to go ahead and get us started, we'd appreciate it.
Will do. Yeah, we workshopped this a couple weeks ago, I think, preliminarily. At that time, we had just workshopped one definition, which was expanding the definition of abandoned, and then the board asked if we could maybe also add a definition for alienation, which would cover if the other parent or guardian was potentially keeping the children away from the alleged abandoned parent, that we could cover both scenarios. So if a parent maybe abandons their child, we have built in this definition, which I'll get to in a second, of where we could use that in part as a justification for adoption per our tribal court in our code. But we wanted to potentially cover a scenario where maybe I'm keeping my kid away from my ex, right? So they didn't abandon them. I'm actively thwarting their relationship with them. And we wanted to make sure we had both sides of the coin covered, so to speak. So.
Yep, and for those on Zoom, we have Jamie Moran and Melissa Van Leuven along with Jennifer Constantine here as well. So any questions, comments from the board before we move forward? Okay, Jamie, do you have any issue with this?
Yes, I do.
Okay, go ahead.
You're quick. You're really quick. The alienation definition. So that obviously would have to be documented because the two, it seems like could go hand in hand. Yes, they abandoned, but the other parent can say, no, she alienated me. I think we talked about that in the workshop. So that would have to be some very heavy proof that there was alienation by the other parent, correct?
That is correct. And down in the proposed changes to grounds for involuntary termination of parental rights, we have here in 1A, B, C, that substantiated evidence of alienation shall be an affirmative defense to allegations of abandonment. It's up to the court to decide, right, the weight of the evidence. But if my rights are being involuntarily terminated, and I have documented evidence that shows, no, my co-parent is stopping me from seeing my kid, and I can prove that to the court, it is an affirmative defense for a finding of abandonment and could stop the adoption from going forward.
Okay.
Based on that basis. There might be other bases that.
Definitely has
later
to have evidence of that.
Correct.
Okay, thank you.
Okay, anyone else? And for the benefit of our membership, a tribal citizen reached out and she has a pending termination against her biological father without giving case specifics or mainly names. She wants to terminate the biological father's rights because he hasn't had contact with the child in about 10 years, but because we don't have a provision in Chapter 30 that utilizes abandonment to support a termination, that family can't do so. So that father, even though he hasn't had any contact with his daughter in 10 years, still has his parental rights intact. The family isn't able to terminate his rights and then have the stepfather adopt the child who has been, more or less the father. So we're just trying to come up with a common sense approach that can help the family, but at the same time also preserving the protection that ICWA provides. Kim.
We asked Jamie her thoughts, and I don't think we ever gave her an opportunity to speak, if we could.
Thank you. In my professional opinion, the changes that are being proposed for this code are extremely risky for the very reason that Chairman Lowe stated, as it would potentially affect permanency for children in state court. You're proposing revisions to tribal code. So this is going to increase the likelihood that you're going to have tribal citizens in tribal court who are going to lose their parental rights because of the abandonment clause. Our culture didn't work that way. Our language doesn't have a word for goodbye. It's bamapi. We will see you later. In November, this board authorized a modification to code to allow for a customary adoption where that relationship with the biological parent is not legally severed. What is being proposed today is in complete opposition to what was done in November. And I'm hanging my hat on the cultural piece. As Native Americans, we don't do that. It's community, it's access to your tribal heritage, and this undermines that principle. Did you have anything to add, Missy? It's very scary to me. The other thing too, with the substantiation for alienation, whose responsibility is that? Is it the judges, the parents? Is it our attorney? Is it an agency authorized to make a finding, a substantiated finding that that occurred? All of those pieces are missing. And what's going to happen in state court? We're going to have more parents terminating the parental rights of the other parent for basically nothing. There's no risk of harm. ICWA says serious risk of harm, and that is not occurring. These code revisions are allowing that to occur, and that is dangerous.
Okay, anyone else speak? Okay, go ahead, Kim, and then Missy.
All right, are we in closed?
No, this is open.
Then I'll wait.
Okay. Maybe if you need to close it down, we'll have the open part first, if that's
Okay.
okay with Austin, and then we'll close
We
it
can do
down.
that, yep. Missy,
I guess, as the Child Placement Program Director, I've been in my role for 20-plus years, and my concern with this change is, as you indicated, Austin, it is coming out of a case that has certain factual circumstances, which is really probably less than 1% of the cases that we deal with as child welfare. It's very unique, I feel, in the world that I work in and that we work in every day. We're your boots on the ground to go out into the community and across the country and make sure that the protections of ICWA and MIFPA in different state law are put into place for our children and families. And so my grave concern is that by changing this, it is weakening the protection and the support and the legal defenses that we have, that we use on the daily for thousands of children and families, kind of in response to one case. And I'm not an attorney. I don't pretend to be. I'm not the be-all, end-all. We have a child welfare committee, we have a board, we have various courts, but just from someone who's done this work for this many years and who's had that experience, when we're dealing with child welfare, fathers are oftentimes not even considered. We always push to find them, to offer them support and services, and just the different standards that would be applied with this change for all cases, because that's when we set those legal precedents in state court and in tribal court. They don't just affect one child, they affect all of our children. And so I just am thankful that you give me the opportunity to at least express my concerns to you, because, like I said, it is something. I woke up this morning just feeling the weight of this. It's been an ongoing discussion, but for me, we always have to speak for all of our children and families. And I feel like a lot of times in the work that we do, we end up not always being able to make the best, the most perfect decision, because we are always have that mind on all of us, right? Our tribe, our children, our families, and each legal case that goes up has the ability to affect all of that. We just saw a case not long ago that went to the Supreme Court, and the protections were upheld, and that was not what everyone expected. And so every day we're fighting battles with agencies, with courts, to keep the protections in place. And so I just wanted to make sure, and I'm not saying that you don't, I wasn't part of the discussion, but the impact, in my opinion, is far-reaching and huge. And it's no disrespect, because we have a committee and we have attorneys and staff who work every day to look at each case and each child and each family as an individual. But I think there's a huge potential here for some, far-reaching consequences. And so I don't mean to be disrespectful, but I just wanted to make sure that the board was thinking in that frame, because it is something I do every day, like I said, thousands of times a day. we're working on this, so, thank you.
So I have Kim Gravel, Kim Lee, then Lana. Does anyone else want to speak after that?
Okay.
Bridget, hold on. Anyone else? Okay, I'll say some things after Bridget then. Go ahead.
Melissa just said what I was going to kind of take into closed session. It was about the one case, is what I was thinking about. That's going to have a far-reaching effect. And, but we did task you to come back with this, right, Ryan? So, okay.
That's correct. This was a more of a board-driven, we had discussion, and no one objected to me bringing some language that I tried to do the best I could to create a framework that would not cause maximum damage, but also I wouldn't say that I'm recommending this course. This was
Okay.
my language trying to find something to present to the board that may be able to be used for the purposes that we discussed previously, but that's why I wanted ACFS and, Jen, I already spoke to you last workshop about this, their input too. And they're not always going to be aligned with mine. I'm not sure that I think it's going to have as big of an impact that it could have. But I am not our ICW attorney. I am not working day in and day out with our child welfare department in state court or our tribal court. That part of my career was in the past, so I don't do that day to day. So I certainly don't have the same perspective that our other staff have, and I value their input as well, right?
So if we stay the course without this, we're okay? Do we need this? In your opinion, as ACFS is what I'm thinking. And I know you tried to do it without, like you said, the far-reaching damage that it
doesn't,
could.
yeah, right, this definition doesn't, the abandonment still has to be judged according to our customary practices. It's gonna have to go hand in hand oftentimes with our customary adoption. Sometimes they will be at odds with each other if it's a civil suit between two parents in our court in the future, especially when we're separated, government, right? That I want to involuntarily terminate my ex's rights so I can have my new spouse adopt them. That might be, that very well could be at odds, right, with our customary adoption part of our code, but there still is that framework where we can and should take in those customary practices into account. So the purpose was not to override those traditional and customary practices, but as well as we can, and it won't work every time, to Jamie's point, have those work in tandem, right? That's why we didn't eliminate that section that's already in our code, that it must be judged, it's a shall, right? It shall be judged through our customary practices in our community. So that part is purposely left in, right? We don't want to, I did not want to propose diminishing that, right? So.
But on the other hand, it's not customary what was threatened if we didn't do it by the individual.
Say that again, Kim, sorry.
That's why I say maybe I better go into
Oh,
closed.
okay, I got
Okay.
you, yes. Adoption in the Western sense is not, and Jamie can articulate this better than I, but the way that our Westernized courts deal with adoption and involuntary termination of parental rights is not customary. My grandpa down in St. Ignace, he was adopted in a customary sense. He was raised by other relatives, right, and family members. We never did a formal adoption. His parents couldn't and didn't want to take care of him, and so his aunt and uncle did, and it was what we now would call under our code a customary adoption. So certainly, I do not disagree with anything that Jamie is saying in regards to how we traditionally and customary have done this. At the same time, we are developing our court, and we live in a world where we have taken a lot of Westernized law and made it our own. We work in the framework of our own codes, and we in MIFPA and ICWA, and there's always that intersection, and it's not always a collaborative one of our Anishinaabe traditions and the Western law. And this is one of those times where they maybe butt heads a little, right? So.
Kim Lee, Lana, Bridget.
Did Jennifer weigh in on this at all?
She had spoken 2 workshops ago, like, when it came up originally, she had given her input on, at that time, what we were presenting, yeah.
Okay, did you have anything else you wanted to add?
I don't think I have anything new to add, just kind of the same concerns, I think, regarding the far-reaching impact of this decision, depending on what, legally, I feel like that's kind of where I need to keep my comments, is obviously the legal framework of it. So I'm worried about some of the cases I've seen in the past where there has been true parental alienation, because we have had several come through, and what would have happened in those cases had it been under the new framework instead of, or the newly proposed framework instead of the old framework. And because those fathers would have lost rights that they probably shouldn't have. So just trying to make sure we keep the broad picture in mind instead of just one case.
Okay, so unfortunately, our traditional and cultural ways, as much as we'd like to hold on to those, right? These codes take all that away from us anyway. And we have to have them to protect kids or people, everybody. So is there any proposals that, I mean, because every caseload is different, right? It's not a one-size-fits-all, and that makes it hard. Is there anything that we can change about this, that we can put those protections in there, whether that be a longer time frame for abandonment, or is there anything that you could propose that would make it a little more safeguarded for everyone?
I guess not that I can think of off of my head. I did review the proposed language, and I think it's written in a way that does kind of limit, I think, the far-reaching implications, as Ryan stated, to the best of the ability right now. But I think there's only so far you can go with the language of that if that's the route we decide to take.
Okay, thank you.
Lana, Bridget, Rob.
Yeah, Kim and I were actually on the same page there because, after our last workshop, in the discussions that we had with everybody at the table, it seemed like everybody was at the same foresight to find out a solution on, it's not thousands of cases, but it's probably more than one in the one we're talking about. Because Austin spoke about it very well. There is a concern if something happens to a Native parent and an abandoned parent gets that child. That is a child welfare issue. That definitely is. So with Kim asking if there's any kind of remedy, if we say a 15-year limit, a 7-year limit, something, because all in all, there's more than one. I mean, there's more than one that we go to court for, and a non-Native parent has the continuity of a family, and that's what we want. Whether they're Native or non-Native, if there's a family unit that wants to protect and take care of a child in a family, we want that as well. So there's got to be some kind of recommendation that we can come up with, and maybe it's not thousands of cases, but clearly laws get changed in order to protect people, and that's every people. That's all families. And in this case, what's going to happen is going to happen, but I think that I think it's just a travesty that we can't find some language that's gonna, the alienation language that was in there, and that was per you guys, because you brought that up, saying, and I realize some parents do that. But like I said, Austin explained it quite good last time, and there is some harm that will come to a child if they don't get secured in a family unit, and have to leave thousands and thousands of miles away from their homeland with a non-native parent that they don't even know. So that is also our responsibility to figure out how we can protect, in my opinion. So, yes.
So for the benefit of everyone, here's what we're talking about. And again, I'm not going to mention names, but the family that I'm talking about wouldn't have an issue with me discussing it. I mean, if we gave them the release of information, they would sign it right here on the spot. So you basically have a Sioux Tribe family that consists of a biological mother who's a Sioux Tribe mother, right? So you have a biological father who hasn't had contact with his biological daughter for about 10 years, since the baby was about a newborn, right? So biological mom has gotten married to a non-tribal member, which makes him tribal household. She's had 2 additional kids with that non-tribal member who's tribal household. They've gotten married. What they want to do is create permanency for that first child by terminating the parental rights based on abandonment. And if you terminate, then you open the door to allow an adoption to take place with the stepfather. So again, the father in this case is not tribal. He hasn't had any contact with his daughter since she was a couple months old. He resides in Wisconsin. He has a history of domestic violence out there. And because his parental rights are still intact, even though he hasn't seen his daughter since she's been an infant and now she's 10, if something happens to biological mother, since biological father still has those rights, there is the potential that that daughter could be placed with him. And we don't know whether or not it could be done under a treatment plan. We don't know whether it be done under the, here's your kid, we're walking out, because it happens both ways in child welfare, it really does. But it's also important to note that even though this is an ICWA case, this is not a child welfare case. So ICWA was created essentially to preserve Native American culture for kids that were removed from homes and placed in non-native settings. That isn't that case either. Again, we have a biological mother who's the tribal member. Biological father is not a tribal member. He's not a tribal household. And essentially, the stepfather who wants to adopt a child is a Native American household at this point. So there's the danger that the child could end up with biological father because he still has his parental rights intact, even though he hasn't laid eyes on his kid in over 10 years. And there's the issue with domestic violence. So at the end of the day, I think the board of directors wanted to create an avenue for the Child Welfare Committee to use abandonment, long-term abandonment, as a grounds of termination to provide permanency for families in this type of situation. So just because you do a code change doesn't mean that every situation is going to go down this route. At the end of the day, the Child Welfare Committee still has the autonomy to make recommendations for permanency. Just because this tool is in there doesn't mean that they're going to recommend termination for every father who hasn't seen their kid in a decade. But I have 2 kids. I have 1 on the way. If you haven't seen your kids in 10 years, you don't deserve parental rights. And if this case was not involving a Native American where ICWA applies, his rights would have been terminated based on abandonment, but because the child is Native American, then you have to apply a completely different set of standards that makes it harder for this family to become a cohesive family unit and to have permanency by stepfather adopting the child, which the termination has to take place first. So again, this isn't a child welfare issue where a child's being mistreated, where the potential for a child to be placed in a non-native setting is there. Like, it's not that at all. I get it, this is a rare case. But, I mean, I don't agree with you guys that there's going to be far unintended consequences. At the end of the day, the Child Welfare Committee still utilizes everything in that code to make a permanency recommendation. And I stand by it. If you're a deadbeat dad and you haven't seen your kids in 10 years, 9 years, 8 years, 1 year, 2 years, you don't deserve to have parental rights. You don't deserve to have them if you're non-tribal or tribal. And I firmly believe that that's what my culture is all about. You're there to take care of your family, and if you're not, move out of the way so someone else can. So that's my position. Respectfully disagree with you guys as a social worker myself. I don't think it's going to have that type of unintended consequences. On the contrary, I think it'd be used on occasion to really help some families that are in this situation. And if it does cause those unintended consequences, we can change the law again to reflect that. That's the thing with codes. They're fluid. It just takes a board majority to change them. And if we're having a disproportionate amount of fathers who are being alienated from their kids, having their rights terminated, then we can change it back. But I mean, I take alienation with a grain of salt as well. People can obviously do that, but I can also get a job, maintain employment, hire a lawyer to be able to get some custody over my kids. If I care enough to do that, then I can. And I get it that there's extreme situations where you can't, Jamie, But as a father, if you want custody of your kids, you can have it. If the biological father of your kids said, Jamie, you're not having your kids, I bet you he wouldn't be able to keep them from you.
If I was mentally ill and addicted and homeless and living in poverty, I don't have access to the same resources that you would. That's what we call privilege. And we can't ascertain one way or the other if that's the situation that the other parent is living in currently.
But if you place a child with all those issues, it could create imminent risk of harm.
There's no harm in the current situation. We respectfully agree to disagree.
But if the mother dies and is placed with a biological father, which we don't know the situation, it definitely could be there.
It's a risk.
Yep, absolutely. So let's get back to the speaking list. Bridget, then Rob.
So I respect you guys' opinion. You guys do this on a daily. I also would like a solution for the family. Would we be able to look into changing the membership ordinance? Because I know that was talked about as well, with the fact that parents can't disenroll their kids right now, and who are we to tell people if they can't? And I can understand that maybe being an issue prior, but now we have open enrollment, and I don't see enrollment closing. So if they wanted to use that as an option just for this case?
So a couple things to add on that. So historically, I believe the tribe has been reluctant to allow that just because if someone has an open child welfare case that's being tried in tribal court, they don't want the possibility that, okay, I'm just going to disenroll my kid. But this isn't that situation. It's not a child welfare case. You know, they have a petition to terminate parental rights, but obviously because the kid's a Native American, it goes through our process. But yeah, I mean, we're a lineal descent tribe, so you could have 1% tribal blood. But once you enroll your kid, you're locked in. And if you have a situation like this family is experiencing, and if you have a tribal child welfare committee that's unwilling to support a termination to create permanency for your household, you can't disenroll your kid, which is an issue. Like, I can see where it's not an issue, where it's perfectly appropriate if you do have that child welfare case, but in this situation, you don't have that.
And Bridget, in response to that, we are working on potential language to maybe allow that for different scenarios, whatever they may be. But that still wouldn't give the tools necessary, because under MIFPA and ICWA, if they're eligible for enrollment, we can intervene. It doesn't have to be, they don't have to be a citizen, like a enrolled citizen. They can just have to be eligible for citizenship. So it doesn't quite solve that conundrum, so to speak. And I told Jen this. My staff never has to agree with me. This was the language. I spent a lot of time, and I looked at a lot of codes, state and tribal codes, to see what other tribes are doing, what might work here. And this, I'm not sure how much I would tweak this. I think this creates a good sideboard that covers a lot of the scenarios we talked about. But I told my staff, like, you can disagree with me 100%, but this is what I'm going to present to the board, because I think this is the best way we can do it and the most protective way if the board is going to go down this path. And like you said, Austin, this would control our court and our nation, but it could be used as a tool to then give testimony to that effect in state court, like, hey, here's how we look at abandonment at the Sioux tribe, and so this can be a risk of harm if this gets adopted for persuasive evidence in a state court. But it is certainly not binding, nor a slam dunk, like you said, Austin, in a state court, but this is a way to create those tools so it controls our nation and can be used to give our staff the tools to have different types of testimony at the state court level. So.
Okay, Rob, then Tish.
So I have some mixed feelings on this one, because I agree with the chair on a lot of things. I have a very low tolerance for fathers who don't take active roles in raising their kids. I had a loving mom and a dad, but I was raised primarily by a single father who you literally would have had to kill to keep his kids away from him. So when a father doesn't take all necessary actions to be involved with his children, I do think that's a risk of harm. At the same time, as a child welfare committee member, I have to take what our ACFS staff and our ICWA attorney saying. with a lot of realistic expectations that there could be some harm in setting case law. So I completely disagree with the notion that, hey, this is our code, we could change it. If it doesn't work, we could change it back. It might be too late at that point. You might have set drastic case law to be used against us. So, you know, I know I'm not in an open meeting right now. Well, we're in an open workshop, but not a meeting where I could motion, but I would motion to refer this back to the Child Welfare Committee and to come up with some further options. Now, another option that I have that might protect us a little bit more would be to keep our code as it is now, but add something in it with extreme and rare cases like this, when a certain amount of boxes are checked that the Child Welfare Committee deems to be appropriate, that they could bring motion to the board in extreme circumstances and present a case to us of why we need to withdraw from this case and allow termination to happen. What I don't want to see, and I take alienation with a grain of salt too, but my views on that have changed a little over the last couple of years, because when you review cases where fathers have extreme harassment happen to them or threats of false allegations, it can make it almost impossible for them to want to engage in that kind of action. So it's really sad to see, but when you have one parent telling the other, if you continue trying to see your kid, I'm going to say this, this, and this about you, and that could have extreme circumstantial effects too. So it would be my position to lean on what our ICWA attorney and our ACFS staff had just said, and I would like to see this go back to the committee so we could have a long discussion about it and figure out what some of those options might be. If we think that, you know, that it could have far-reaching effects, then maybe it does need to be handled on a case-by-case basis, where the committee comes forward and says, look, we believe that this really is abandonment and there is some effect, or even like this, if we have a case brought to us at the board level, maybe we could have a meeting with ACFS and our Child Welfare Committee and say, does this check all the boxes of abandonment? But, you know, as long as our ACFS staff and our Child Welfare Committee and our ICWA attorney saying that it could have far-reaching effects, then I can't support it. And I definitely think in the case that we're talking about right now, we need to find some solution, though, because this isn't right either. So I think that I also think that maybe we went about this a little too fast and it needs a lot longer discussion. So that's where I'm at with it.
So just to give you some information, because we've referenced this family, they have their termination hearing later this week, so referring it to that committee will do them no good. They've had various termination hearings, the point where the biological father doesn't attend the court hearings, where he's got an attorney representing him, basically an empty chair. So that's what we're dealing with.
I agree with that, but at the same time, as I'm not willing to take quick action to fix things for one family, when we just heard our staff and ICWA attorney tell us that it could have far-reaching effects, I'm not comfortable with that.
Okay.
Two things I want to caution in response to Rob, I don't want to, if they don't mind, but so before I forget them. One, if we go down the route, and I don't want to go down this route, and I don't think, I don't want to speak for ACFS or for Jen, but I think they would agree. We don't want to go down the route, I don't believe, of where we're possibly withdrawing from a case, because under MIPA, they still need to have qualified expert witness that put on testimony for risk of harm, and it's way better if we are at the table doing that testimony than if we withdraw from the case and they get some random so-and-so doctorate who's maybe not even tribal to be at the case. I would very strongly caution against going that route. And then the second thing, crap, I just lost it. The second thing that I wanted to flag, Rob said, was, it is far better to probably do this through a code change that is universal, if we're going to do it at all, than to come to the board and piecemeal it, where we say this family has these circumstances and we want to apply something this way, because that way it doesn't eliminate the long-term potential ramifications, because you're still going to go into state court and you're going to put on testimony after you've checked all those boxes, and the result's going to be the same. So I think it's far better to try to find, if we're going to go that route as a nation, code language that can work broadly than to pick and choose families because it doesn't eliminate the risk that you have your staff telling you. So those are just two things I want the board to keep in mind as we continue these conversations.
Okay, I might have misspoke there because I'd never believe that we should withdraw from a case. I meant change our position.
Okay, you
in
said
the
withdraw,
case.
so I
Yeah,
want you we're on the same page.
I meant change our
Okay.
position to termination.
Okay.
That should always come from the committee, and I believe that we should be at every court case, no matter what, involving ICWA. The other thing is, I see what you're saying about case by case, but it sounds like listening to our ACFS staff, members of the Child Welfare Committee, and our ICWA attorney, that we might be still not narrowed in enough in scope of what this code change might be. I 100% agree that the cases that we're discussing right now need an avenue for recourse, because I do see risk of harm when there's abandonment. There's risk of harm in not having the security of permanency. There's also a risk of harm in turning a child over to a parent who hasn't had anything to do with them in 10 years. There's risk of harm in turning a child back over to a parent who has proven to be violent or have a case of domestic abuse. So I would disagree with the notion that there's no risk of harm here. I think there absolutely is. Maybe there's no risk of harm today or tomorrow, but God forbid something happened to that parent who's taking care of the child right now, and we turn them back over to a parent who could be dangerous. That's a risk of harm. And I don't think there's any argument against that. But what I will support is that we have a deeper discussion at the committee level with our ICWA attorney and maybe narrow in the scope of this, so that way we're not setting ourselves up for setting a bad case precedence. And like the chair said, it might not help with the case that we're talking about right now, you know, in a timely manner, but I'm really worried about taking fast action to address something. When we have staff, committee members, and the ICWA attorney telling us it could have far-reaching effects. So I 100% want a solution for this, but I want it to be a solution that our staff and ICWA attorney is comfortable with.
So do you have recommendations as far as how we balance this, like abandonment with the potential for parental alienation? Because that's what we're talking about with the potential for far-reaching consequences, that you have some dad out there or mother who hasn't been able to access their kids, and then that former partner can use that to allege that they've abandoned their kid. Like, how do we balance it? Do you think there is a balance?
Austin, I think you kind of explained the issue in this specific situation. In order to get to the action that was filed before the court, there has to be an involuntary termination of parental rights, and that's a different body of law. And that body of law is where we deal in our child welfare cases. So those cases have a different standard and a different tone from the very beginning. And I just wanted to clarify, because I wasn't being dramatic saying thousands of cases. Like right now, we currently have 400+ open, active legal cases across the country and in tribal court. But the tone of these cases start with a CPS investigation. So we also have probably twice as many cases where those standards of, do we find dads, do we engage dads, do we offer dads support, are they a resource for their children, is happening, and that standard comes from the law and all the way down to the cases that never get to a court. So I wasn't meaning to be dramatic, like when I'm saying thousands like of our Sioux Tribe children in this system. As far as, I don't know how to connect it, because it's not taking into account the way the law is structured. It doesn't take into account MIFPA and ICWA. We only have an option to go over to that other code or other state statute, and that's where the protections come in. And when you, like, it's completely different world. The standard that's used for parental custody and abuse and neglect are so far different, and the expectation, and that's the expectation that we walk every day into homes, agencies, courts, and ask that everyone adhere to, because of the standards and the beyond a reasonable doubt standards that apply to the cases for termination. And when you flip to a parental custody case, it's a completely different version, it's a completely different world. There is no agency staff, there's no one providing any of that support. And luckily, if you're someone who has resources and options and support, you know, you can make your case in that world. But for, as Jamie spoke, people who don't have that, like, that's where we step in our cases and make sure those things are provided to them. So that when we involuntarily terminate parental rights, it is beyond a reasonable doubt. We have tried everything that we can before we take this step that is not something that we really want to approve in the first place. So I don't know, Austin, but I just wanted to kind of, like, when I'm talking from abuse and neglect view.
I understand that, but this case is unique because there's not that initial CPS report, because there's not abuse or neglect, there's not maltreatment. You know, and if this is a non-native child, that biological father's rights would likely be terminated because of abandonment, because you can do that if you're non-tribal. But if you're tribal, you follow ICWA, even if the person that you're trying to terminate the parental rights on isn't tribal. And then, you know, abandonment is tricky, and you could be a non-tribal member, white person, black person, Asian person. You know, you fathered this child, but you have the protections under ICWA, even though you offer nothing of cultural importance or value, which is why ICWA was created. You're more or less, and I'm not meaning you guys, but it more or less creates a situation where it's more difficult for a family to get permanency. It just is, you know, so. Who else is on the list? Tish.
So, thank you. So for the child welfare, well, me personally, I guess, I don't know if trying to go to state court and make our code fit that mold. I would rather see us look at our own adoption code and put some language in there and then give them standing in tribal court. There we don't have to really worry about consequences of us changing our code and with state court and what they feel for us. We have hostile courts in our own service area that my fear, as being on the child welfare committee for 10 years, is them using it as a tool to cut us out. So I would rather give them standing in our own tribal court and do something under our adoption code that gives this family and other families in a similar situation to be able to do that. That's where I was coming from. I just want to make sure I want to get that out there.
Okay, I appreciate it. I don't see any more hands, so again, respectfully, I disagree with you guys on this. You know, I think that the CWC committee could benefit from having this as a tool. I don't think it should be harder for Native families to have permanency when you have clear-cut examples of abandonment. If someone hasn't seen their kid in 10 years, you know, it is what it is. I mean, I'm a social worker. I'm not trying to diminish the protections of ICWA. The biological mother in this case is a licensed master social worker as well that actually teaches child welfare at the university level, and I don't think she's trying to do that either. So I think this offers a common sense approach to, you know, rare cases such as this one. And when we talk about consequences, this is a consequence of our interpretation of ICWA. You know, a family feels screwed over by their tribe, you know, plain and simple. So any further discussion on this? Rob?
I would like to take a closer look at what Tish just suggested, to see if there's room that maybe we provide jurisdiction to our court to handle cases like this, rather than putting it out in state courts.
So Jen, would we still have to have biological father's rights terminated? And would we be able to do so through our court without an abuse or neglect case to initiate that?
I think it would depend on the language that you adopted when you gave them jurisdiction within tribal court. Because obviously ICWA and MIFBA don't apply within our tribal courts. So you lose the requirement of having to have a qualified expert witness and those type of things, which is where a lot of our concerns do stem from. So just, I mean, it could be done. There would just need to be, I think, a lot of wordsmithing and figuring it out and making sure it's a route we want to take, because it would be opening up tribal court jurisdiction to a non-native parent who wanted to terminate against a parental parent or a native parent in the same situation. So if in this given situation, the status of the parents was reversed, are we still comfortable with allowing that parent to access tribal court to terminate against the tribal parent in that case. Because the way the code is currently written, we define status based on relationship to the child, not relationship to the tribe. So I think it would require a lot of changes as far as what route we want to go with that. So just something to be aware of.
Okay, go ahead, Aaron, then Missy.
So if we, all right, that might be the solution, and I think it could be done in a way that doesn't run afoul of ICWA. If we allow for, if we provide for adoptions in tribal court in cases of an absentia, so we don't even have to say abandonment, because if we make notification to the biological father who's non-native and we've made good faith efforts and they're just not responding, that we can proceed on an adoption of a non-native adopting a, see, here's the problem with that though, all right? So how many times have we had, and it's mostly Indian women on the reservation who have a partner who's non-native, put them on the lease, and then once they beat the hell out of them or molest their children, and I could be very specific on that one, want the perpetrator out of the house, and they're on the lease. In one case I know where a perpetrator molested a child but was on the lease and would not leave. And the mom and the kids had to scramble their belongings together real quick to get the hell out because the creep would not leave. So, but if we can think it through, because maybe we're onto something, in absentia, but allow for a due process step somewhere down the road where if the biological non-native parent shows up, you know, whatever. You know, here's the thing is we're forming lots of opinions at this table about what I would do or what you would do or whatever, and we're doing it mostly in terms of the rights and protections of the parents, right? And there's a new body of law that's emerging, and that is the human rights and protections of the child. The child's rights should be preeminent. And while I don't appreciate deadbeat dads, because most of my family members, my relatives that are female that have deadbeat dads aren't paying child support, they're just totally useless, and they're mostly non-native. And they should be out of the picture. I'd like them out of the picture. Every time they show back up for some kind of visitation, they just create turmoil, and, you know, as soon as they get out of jail, they come and visit, and then they go back to jail, and that is not in the child's best interest, but who am I to say that? You know, the child's needs should be preeminent. And if a father comes back into the environment somewhere down the road, you know, is it our right to tell them that they shouldn't have access? And ICWA doesn't provide for protections in that. We've had cases that have gone up to the Supreme Court. So what I'm thinking is if there's some kind of an adoption, if we can write an adoption that has to go through some due process, notification, and in absentia, if we can't reach the biological parent and they're non-tribal, then we can afford an adoption to a non-tribal. But here's the potential problem there again, is what happens when, you know, and you got to think in terms of cases, not specific people, right? So in this case, it sounds reasonable. This woman sounds wonderful to me. The father sounds like a deadbeat to me. But what happens if there's a divorce and then there's a custody battle between the tribal mom and the non-tribal father that we gave an adoption to? Because then that person's going to have rights, right? So, but I don't know. I think I don't know the whole situation because I don't think it's our job to delve that deep at the policy level. And we have staff that are experts in this that's their job, right? So that's not to say that staff are above reproach, they don't make mistakes. Quite frankly, I don't understand why we're interpreting that other than we don't want to terminate someone's parental rights with not being able to reach them. So if that's purely the situation, but is there a time frame? Maybe if we develop, if that's what this abandonment code would be, just a time frame, because we can't leave it hanging, the family sanctity hanging forever, because we can't reach the person, because there are deadbeat people who don't want to be reached, and they'll never be reached, So, I mean, I didn't come to a solution on any of that little soliloquy, but it's a matter of balancing rights, and we always got to remember that the child's rights are preeminent over either parent's rights. They should be. That's the way we're going. I've read the law too. That's the route we're going. I don't know about right now on the federal level, but so this case though is not even in court though, right? The attempts are in external court, and then we're just perceived as tripping it up because we won't terminate the rights of the parent, or?
It's in Mackinac County Court, Aaron, because the child is a Native American child. ICWA is triggered, so we have an ICWA monitoring worker, and they have to go through the process with the Child Welfare Committee. Child Welfare Committee makes permanency recommendations. It's my understanding that it's not a consensus decision when they vote on this case already. Like, it's kind of a split room. I could be mistaken, but that's just what I've been told.
So we're not intervening to try to stop it. We're just not testifying to what the mom wants.
No. We have intervened. We're monitoring, and we're intervening, and we're not supportive of the termination because we don't have anything in Chapter 30 that gives abandonment, that allows abandonment to be used for a termination.
So have we filed a motion to prevent whatever the mom's trying to do, or have we been called to testify and we can't agree? 'Cause
Yes.
those are two different things.
At this time, the position would be, or the status would be that the qualified expert witness would not be able to provide the mandatory risk of harm testimony that would allow the involuntary termination of
We're
parental
not
rights.
petitioning the court to prevent what the mom's trying to do. We're just, in our best professional advice, using both staff and committee as the experts, we're not agreeing to what the mom wants, and we're not providing testimony to what the mom wants. But so that's why I said, and I used the term correctly, we're not intervening. We are intervening because it's an ICWA case, because we made a determination a long time ago that we would always intervene in every child welfare case, but we're just not conveniently agreeing to what the mom wants, because in our professional opinion, and that includes the legal department, the legal attorney for child welfare, our director, and our staff, and our child welfare committee, all are on one side of this issue. So I'm really uncomfortable, we've blurred the lines in the last couple of months incredibly, as we get very close to separating powers, it seems like we're at risk, and we are blurring the lines and overstepping. I think at the policy level, we're overstepping too much. And so I don't agree with it, but if we can find some kind of intermediary step that could do in an abstention, an adoption, as long as it has a provision to be able for the biological father to repetition, because here's the reason, okay? Because if you go to our drug court and you watch the rehabilitation that happens all the time, probably 90% of those people should have had their kids taken away on day one. But we believe that people can be rehabilitated, and we give them the opportunity to be rehabilitated. And certainly we would want one of our own people to have the opportunity to petition to get their child back if they get their life together, if they're in a different situation 5 years down the road, so there's no healing involved if we're just terminating somebody's parental rights. This is a hard one to argue for, because if this father has truly just not made any efforts, it seems like they should just give up, I guess, whatever. But I don't know what the answer is. But I don't think it's right for us as the policy level to be trying to overturn decisions that are made and the structure that we've created to be able to advise us. And that's not to say that you guys are infallible, because I've had situations myself.
It's just to clarify, because we do at any given point in time have several step-parent adoption cases open in state court. And whenever that does occur, I reach out to the petitioner's attorney and say, you understand our qualified expert witness is going to have to testify to active efforts and risk of harm. What information can you provide to me that I can take to the Child Welfare Committee regarding risk of harm and the efforts you have made to reach out to this parent? And we have at times had Child Welfare Committee support the involuntary termination of parents in a step-parent adoption. It's not that it never happens. They do case-by-case analysis based on what the petitioner or petitioner's attorney provide to them. Sometimes we get information from counselors, children's counselors. Sometimes we get police reports. Sometimes we get all kinds of different information. Sometimes it's just really heartfelt letters from parents that get presented. But every single thing that those petitioners give to us gets presented to the Child Welfare Committee and is considered in their case-by-case analysis as to whether or not they believe there is risk of harm. They then make their recommendation, and our QEWs, they're the ones who present the information to Child Welfare Committee in those cases, because they're also the monitoring workers, make the decision as to whether or not they feel, as qualified expert witnesses, can testify to, beyond a reasonable doubt, that they feel that there is risk of harm to this child. So we do always ask for that information up front, and there is a case-by-case analysis done in all of these cases. Within the last few years, I know we actually did have an abandonment case where some extra information was provided. We did end up supporting the involuntary termination, and the adoption went through. We've also had a case within the last, I would say, 2 months where we refused to terminate under just the abandonment clause, and it prevented the termination of the native father's rights. So right now, it's done on a case-by-case basis based on the information that those individuals are able to give committee, so.
Okay, I appreciate it, Jen. Any more questions, comments before we go on break? Okay, go ahead, Missy.
Just one more. Originally, when we started the customary adoption code work group in the drafting of that, we had talked about, would that be a solution to some of these cases? And because it does, right now, the way it's written, it requires consent, but there are times when, like that question comes up a lot. If this parent is really not interested, has, for all intents and purposes, abandoned a child, would they be willing to release? And actually, sometimes they are willing to go in and voluntarily release so that the adoption can go through. And then that is not involuntary, but I don't know if it's worth revisiting the customary adoption code. At the time the work group convened, our court was not in favor of having customary adoption applied to voluntary adoption situations for whatever reason, so that was not discussed or included in our customary adoption code. But I don't know if it's worth revisiting that, because again, it takes into account the spiritual ties to the child. It is not a severing of parental rights, but it's a permanent suspension, and it allows the adoption to be ordered. That adoption order should be recognized with full faith and credit, and it would also, I think, alleviate the issues you're speaking of if something happens to this mom or dad and that parent, but it does preserve that. And I don't know, but I feel like it's worth kind of reviewing that and seeing if there's an option there as well.
So it won't be an option for this family. Biological father's unwilling to sign off on his rights, so he wouldn't be agreeable to something like this. It's one of those things where it's a good option if both parties are agreeable. It's voluntary kind of thing.
But the customary adoption does not require them to release their parental rights,
Okay.
like in the same fashion in a state court. It's a permanent suspension. It's not a legal severing of the rights,
Okay.
which is.
Any more questions, comments? Okay, we appreciate you guys being here. We're not always going to agree. I hope you feel like you're being respected in this conversation. We're going to take a 10-minute break, and then we're going to reconvene for proposed constitutional amendments. We'll get through that, then agenda review, then the meeting. So 10-minute break. Guys, we are back in session. The item that we're currently on is proposed constitutional amendment. General Counsel Ryan Mills is going to walk us through this. Whenever you're ready, Ryan.
Yeah, I'm not sure what we're gonna really walk through. This was on here because the timeline resolution mandated that May 6th, I guess is tomorrow, right, was the tentative deadline to vote on whether we send this out to a secretarial election at the BIA. Last week, we went through the informal review from the local BIA office. They gave us their comments. They were minimal. They mostly had no issues with anything. A couple of comments, a couple of grammar, formatting things. We made all those changes per our discussion on Tuesday. We sent out to the board the clean version and sent it to the BIA that Thursday, the 30th, the clean version of our proposed amendments. The BIA now is at their regional office doing a review, and they may or may not have comments that differ from what the local office gave us. ETA, no idea. I have no idea how long they will take to get us those comments. We have not made, besides those grammar and clerical changes, we have not made any substantive changes to our draft. The one that's posted on the website is the same one with those clerical fixes that went to the BIA. It's the one presumably that when we do vote, when this body does vote for it, is what will be sent out to the membership for review. This was set as our kind of last minute workshop for anything that might have been outstanding from the board's perspective or the BIA's perspective. I do not have anything from the legal department's perspective that is being brought forth today. I'm happy to field questions if they arise or there's something we needed to revisit. Several of you have over the past few weeks flagged potential things they want to revisit. I don't know if that is going to happen today or if that's going to happen at all. So I'm kind of leaving it in your court right now on guiding me on how you want this conversation to go, because we have done all the changes. We, meaning the legal department, is more or less happy with this draft. I think it creates a very co-equal three-branch government. It's very workable, much more so than some of our previous drafts. Is it perfect? No. But it also gives us the ability, if this gets implemented, to do amendments as a tribe without the federal government much more easier and much more efficiently in the future. So on balance, I think what the board has crafted here by majority through all those many workshops is something that will achieve that separation of powers in a way that we can go forward as a tribe and implement without too many headaches, hopefully.
Okay, Ryan, before I turn it over to the speakers list, so basically, we have to determine at what time do we vote on this to authorize this, the BIA to conduct the secretarial election. So when we previously passed a resolution that put all those timelines in place, there's a certain date, which I believe is effective a couple of days from now?
May 6th was the
Okay.
date.
It's
May
either
6th
that-
or 30 days from conclusion of the informal review.
Exactly, and for the informal review, we're just waiting for the regional BIA office in Bemidji?
Correct. The local BIA office gave us their comments.
Okay.
There's a second layer that's happening right now. I don't know when they'll get us the regional
So
office comments.
we can add this potentially to the agenda tonight and vote on it tonight, or we could wait until we hear the feedback from the Bemidji office, but at the end of the day, it's up to the pleasure of the board of directors.
That's correct. And when we vote on this and if and when it passes, that will trigger off all the processes under the federal regulations for the secretarial election, including which part of it is what's called a technical review. They're going to review it again anyway, probably with the assistance, right, of the solicitor's office, the attorneys. And they'll do a technical review. The reason we were doing the informal review is when you get a lot of the big ticket items, if they have concerns, out of the way in the informal review, it can speed up the technical review, because it would be their second or third pass on it, which is why the tribe asked me to start the informal process months ago, right? So.
Okay, thank you. Rob?
I believe tomorrow was our deadline to vote on it, unless the board changes that. To be in compliance with our resolution, we would need to vote on this tomorrow or tonight. That's passed. I asked legal to draft a resolution because I will be motioning to put it on the agenda tonight. I don't see any reason to wait. My question to legal is that, just so the board's clear on this and the membership's clear on this, is that in triggering this to the BIA, there will be a technical review, which would basically be the same thing as the informal review that we're waiting on.
It would be, yeah, more or less. It's maybe a little more in-depth technical review than maybe the informal one, but it's basically the same process, except there's strict deadlines in the federal regulations that they'll have to have the election set within 90 days of us sending them the resolution. So it would be, it places a timeline on the federal government where the informal review doesn't, so.
Yeah, I think, our membership's been waiting 20 years, so for us to put this much work into a draft, whatever suggestions we get back in the technical review, I don't see it taking us more than 90 days. Honestly, I think we could do it in a week or two.
Yeah, and the BIA had advised that maybe not the best logistically to do a secretarial election in the middle of our tribal general election. So I worded the resolution for Rob, and I believe Director Payment, you maybe had a draft that had this language too, where we'll wait 30 days from enactment. So if it happens tonight, 30 days from tonight is when we'll send the resolution to the secretary. It's kind of our sort of workaround. So as soon as the secretary gets that resolution, they're going to kick off their processes. So if we have it in a resolution where we're approving it to send it in 30 days, that'll more or less clear most of our internal election processes, because the end of June we'll be tabulating. So then we won't be running our elections at the same time the secretary is potentially trying to run their election, which is something they advise against, but the timing would clear that hurdle, so to speak.
Yeah, and I'm completely okay with that, and I understand the reasoning why, but I believe that this board specifically issued the survey. We did all the work on the constitutional review, and I think this board specifically owes it to our membership to vote to trigger this election. And so I will be motioning tonight to add this to the agenda.
Aaron, then Kim.
All right, so I will defer to the draft that you did. I didn't include any whereases because sometimes people get all in a kerfuffle over the whereases, so, and they're irrelevant anyway, they're not needed. But I'll defer to that. And if we have to add that it will be effective after June 26th or whatever, I'm okay with that too. So, but I agree with Rob that, this has been stalled for 20 years. There's no good reason now, only excuses. And, but I do have a question. But before I ask my question, a board member asked me today, and I won't say the person's name, but a board member asked me if I would agree to moving the legislative override on a veto from 9 votes to 8 votes. If it takes that to get another affirmative vote for it, I'm okay with that. Because I think if you can get 8 votes on the board of directors to overturn something, that's something, right? So whether it's 8 or 9, I would not quibble over that. I would support that. So if we need to amend the language that would change it from 9 to 8, I will agree with that. But if that then triggers, we got to go back out and talk to the people, we got to present it to the people, then I would rather not do that, because, this business about people not being aware of it or not, I do remember, not this election cycle, but an election cycle several times ago where somebody actually said the people aren't smart enough to know what they're voting on. That hurt that person very badly in that election, but I do have a couple of questions. And I would like to poll before we're done today to see if we have 9 votes, or if we would have 9 votes to suspend tonight, and poll on changing from 9 to 8. Those are 2 requests for a poll. All right, so my question is, I have a couple questions. When was the felony prohibition removed from the election eligibility? And then and I think the answer is 2023. Because it
Yeah,
was before I came back to office.
I'll have to
but-
find the exact date, Aaron, but it was in 2023, towards the end, in the fall, when the board did the most recent changes to chapter 10, yeah. December.
Yeah.
I think it was November or December, yeah.
And I support the board's action in that because, as I understand it, the board was trying to be consistent with the Constitution rather than making up criteria, because if you know our history, the felony prohibition was put in place at the direction of a previous chairman to exclude a person in particular. And that is a bill or retainer. You don't write laws that are specific to individual people. It was to deny a certain person to be able to run for office for something that would be a misdemeanor today, right? So that's one thing. The other thing is the background checks were put in place because we totally subordinated ourselves to the Michigan Game and Control Board, breached our sovereignty, totally forfeited our sovereignty. And I'm the only board member that voted against that. None of the rest of the board that are on the board now were on the board then, but I voted against it because it basically said if the Game and Control Board determined that a board member was not suitable for a gaming license in Detroit, then they wouldn't be eligible to be on the board of directors. And that is totally giving away your sovereignty. I was the only one that voted against that. But when the board voted to stick strictly to the Constitution, which does not have a felony prohibition, which I do think that was the right thing for the board to do, then the need for a background check went out the window, because there's no reason to do a background check if there's no felony prohibition. Now, having said that, the board can, not the board, the citizens or the board, in the first round of amendments, after we amend the Constitution, can amend to add a felony prohibition. And I do think if that comes for a vote of the people will vote to prohibit anybody with a felon from being able to run for the board of directors. But it's not currently in the Constitution. So the board's getting attacked pretty bad right now. And, I could say, I wasn't on the board, I had nothing to do with it. But what the board did, as I understand it, is they voted to make the election code consistent with the Constitution, which does not include a felony prohibition. Just one other thing I'll say is that there was a time when somebody, I won't be specific enough so you can't figure out who I'm talking about, but there was a time when somebody who was on the board, the chairman found out that they were adopted and went into their file, breached their confidentiality, and then got the board to amend the election code to add a blood quantum requirement to run for office. That was not in our Constitution. That was not a requirement in any of our election codes up till that time. But when that chairman found out, a different chairman, found out that that person was an adopted person, then added the blood quantum requirement, and then that person wasn't eligible. And then I was on the board, and I'm proud of this. Denny McKelvey and I introduced a resolution to eliminate the blood quantum requirement because it's not in the Constitution. Several board members bitched and complained about it, so we put it to a referendum vote, and guess what? The people overturned it because it's wrong. It was violating our constitutional rights. So anyway, I just wanted to give some cover for the board making the right decision by eliminating it, but the people can add it back in if they want to after the Constitution's amended. Thanks.
Kim?
Okay, I think we should follow up with the Midwest Regional Office review and then send it out for the secretarial election, and by then our 30 days should be up, because it didn't take our local BIA very long. And we're not,
Yeah, took like 35 days maybe for the local, it was about a month, yeah.
and we're not like, what was our guideline for tomorrow was to send it out for a secretarial election or send it for review?
Vote on it.
To vote to send it?
It was to vote to send it by May 6th or 30
30
days
days
after
from
the
that.
review finished, yeah.
So if we wait until if they don't come, and if it passes tonight that we're going to send it out, I recommend you contact the Midwest Regional Office and tell them to stop reviewing it, because then they gotta wait for the resolution.
Yeah, I've already been emailing them, letting them know that
So they got a
the
heads up.
potentiality that it could be voted on sooner than their review is done. Yeah, they're aware.
So, but I think we should follow through with the review and the steps that are supposed to be taken.
Okay, anyone else? Isaac, then Rob, anyone else after that?
I think since I sponsored the original resolution, we amended that resolution and we enacted that resolution, and it does state May 6th, right? So I think Rob and I and Aaron support moving forward to send it to the BIA.
Rob?
I just want to be clear that there's not anything laid out by the BIA that we're waiting on. So to state that we have to wait till what's supposed to take place that was only us regulating that in hopes that it would be done by May 6th. So
Correct, yeah.
we're not actually waiting on any process from the BIA. They were waiting on us to hold a vote, to send it to them. I don't see any reason in making them review it once if we're going to send it out and they're just going to have to review it again and more in depth. I think it makes more sense just to send it out tonight and get that technical review and get it back here. So I see no issue in waiting, and, I know I need 9 votes to do it tonight, but if it fails tonight, I'm adding it in 2 weeks anyways. So, we're going to have to vote on it, and we can have a poll to see if there's enough votes to add it tonight. That's not going to affect what I do tonight. I'm still going to motion to add it, and I think the membership has a right to see who's who on this board, and I hope they all pay attention.
Kim?
If I vote no to send it out tonight, it doesn't mean I'm not against it. I'm saying let's do it right. If the BIA has to do another level of review, that's what we're at right now. It's at the Midwest Regional Office, and I don't want it out there all over Facebook if I vote tonight that I'm against the 3-branch constitution. When it gets here to do it, I will vote to send it out for a secretarial election, but I'm not going to do it ahead of the steps we're supposed to take. Because I know it's going to be all over Facebook. It was just said that. Look at who will say no.
Okay, I have Aaron on the speaking list. Does anyone else want to speak after him? And as a reminder to the board and the membership, what's going on is we're getting an update from our general counsel, Ryan Mills, regarding the step that we're in the constitutional amendment. We can either add it to the agenda tonight, vote on it tonight, or we can wait until we get the feedback from the Bemidji office. So that's what it is. It doesn't need to be a back and forth debate. At the end of the day, motion to get it on the agenda. If you have 9 votes, it will be added. You'll vote on it. If not, it'll just be 2 weeks. So there's no sense fighting about it more than we need to. Aaron?
So I want to make it clear too, because something was just presented that's not factual. It's not a required step of the Secretary of Interior or the BIA to have us voluntarily have submitted the document for their look-see before we take a vote and submit. We did that voluntarily. We set that standard. That's not a requirement in federal law. If somebody wants to assert that, if they want to cite that section in federal law, then please do so. But your legal counsel just clarified that's not a requirement. Rob tried to make that clarification, that's not a requirement. And if we vote on it, if we have no votes already lining up today and giving arguments for the no votes, then we'll just put it on the agenda for the next meeting and we'll do it. We don't need everybody's vote on this. And there are several board members who have said that they will never support it. There's several board members who have never said that they will support a 3-branch. Today's the first time that I heard Director Gravel say that she'll support it if we do it right. But we're not
Support
doing,
to send
okay,
it out for
I have the floor.
secretarial
But we're
election.
not doing it right just because Director Gravel says that we're required to do it a certain way. That doesn't exist in the law anywhere. Your legal counsel just clarified that doesn't exist in the law. We were forwarding it to the region to take a voluntary look at it. However, we now have the local BIA office who I'm not sure why they were permitted to weigh in on it, because that's a Sioux Tribe member. Normally, they would have to recuse themselves. In the past, they have had to recuse themselves. And the examples are the constitutional amendments we've done in the past, the local regional people have recused themselves. But that the process now going to the region is not a requirement in the law. We requested it. And so if we vote on moving forward, it will go through that required process. They'll probably skip the Michigan agency because they've already done their review and they didn't have any substantive changes. And then it'll go to the region, then it'll go to the central office, which is in Washington, D.C. So I want to make it very clear, because you're hearing different things from people at this table than what your legal counsel has just told you. It's not a requirement for it to get reviewed by the region before we vote on it. That doesn't exist in the law anywhere, and if anybody says that, they should cite the law.
Okay, Rob, then Kim Gravel. Kim?
Okay. If it's not in there, we requested it, follow through with it, and I never did say I supported the 3-branch. I said I will support sending it out for a secretarial election. Then it's my choice how I vote on it. But I'm in support of sending it out to the membership. So,
All right, so that concludes the speakers list, and that concludes this conversation. I don't think anything else needs to be said. Let's take a break until 4 o'clock. At that time, we will conduct agenda review. We don't have a whole lot of items to review. Most of them we've workshopped recently. So there'll be 1, 2, 3, 4, 5 resolutions to workshop and agenda review, along with the items under new business. So we'll be on recess until 4 o'clock. Guys, let's get back to work. It is 4:05. Let's cover agenda review. The first resolution that we'll cover is amending Chapter 20, licensing of commercial treaty fishing activities. So all the previous resolutions we've workshopped multiple times. So Lana has crossed them off the agenda review list because it's redundant at this point. So legal and Clarence, can you explain this resolution to the Board of Directors and our membership, please?
Can you hear me?
Yes, we can.
Okay, so, Chapter 20 currently has language that allows, a commercial license to identify two partners and cooperators of a licensed boat. The committee felt that that should be tightened up, and only allow family members to be the, identified on that, on those licenses. So the new language, I believe, is in the resolution. Instead of a commercial fishing license may identify two partners and cooperators of a licensed boat. The new language, if approved, would say a commercial fishing license may identify two tribal family members as partners and cooperators of a licensed boat. For this section, family members shall mean father, mother, son, daughter, brother, sister, grandparent, grandson, granddaughter, nephew, or niece. So basically immediate family.
Okay, I appreciate it. So I have a couple questions, if you don't mind, before we open it up on the speaking list. First one, have we workshopped this one, Ryan?
I do not believe the board has workshopped this one. This was sent over, it was workshopped at the committee level, Conservation Committee, and sent over, but we didn't workshop it on a board workshop agenda, no.
Okay. Second question,
Changes.
is there anything in this proposed code change that would prevent multiple people from the family to be out on the water with multiple votes under the same license?
No.
No, it would,
No.
it would allow that scenario.
So you can have two family members under the same license, so you could potentially have three boats out on the water under the same license?
I don't,
Well,
is that correct?
The commercial captain license would be restricted to one vessel, so having a cooperator that's a family member would allow them to be on that one vessel, but not have multiple vessels. Sorry,
Okay.
I misunderstood your question.
So if this passes, I'm a commercial fisherman, I have a son, you know, we both can't have boats out on the same time or anything like that?
Right.
That's correct.
Okay, okay,
Not under this provision. You have to both have your captain card.
okay.
There's only one license.
And then, do we have any situation in place, well, any solution if you have a commercial fisherman that doesn't have any immediate family members who are willing to work as a helper?
So we have so this wouldn't affect the the helper section is separate, and so they could still have they could find another tribal member who is not their immediate family to be their helper. They just couldn't make them an actual co-operator of their. This was set up originally in code when it wasn't identified in the proposed for just family members to kind of create like the enterprises. So if I wanted to create a fishing operation, like me and my brother, or me and my cousin, I don't know, we would create that like operation together under my license or under his license. And it was totally separate from the helper scenario. That's governed in another part of code, and so that doesn't matter if they're family or not, as long as they're tribal members.
Okay. But right now, if you're a commercial fisherman, the license holder has to be in the vessel for it to be out on the water. Is that correct or no?
That's correct.
Correct.
Okay, okay. Because I've had some people reach out to me that this is kind of like co-captains except for immediate family members. Kind of.
Sort of, but it doesn't allow the cooperator so the co-captain situation, if I'm like ill or something, I can't operate my boat and I assign a co-captain, they can go operate my boat for me while I'm recovering. This is different. I couldn't have my cooperator just go out without me and run my operation.
Okay, all
That's-
right. That
that's
answers my
separate.
questions. Lana?
So if this passes, and I had a commercial fishing license, which I don't, but if I did, my non-native husband, could he get on the boat with me?
No.
No, it'd be,
It has to be
well,
a tribal member still, just like the helpers.
correct.
Okay, yep, thank you.
Anyone else? Rob?
So can you explain real quick the way the co-captains work right now? From my understanding, it would be that they can operate, but the captain would still have to be in the boat?
No, not necessarily. So we very rarely do a co-captain situation. The most recent one we did was we had a fisher who had for health reasons, wanted to name a family member, I think it was his brother, as a co-captain, because for a period of time, he wasn't going to be able to operate his boat. So we set up a co-captain license. So while that licensed captain was recovering, his operation could still go on without him temporarily under the co-captain, but it wasn't like a permanent situation thing, yeah.
Okay, so under this code revision, it would allow someone, let's say a fisherman, who has a brother, sister, mom, dad, aunt, uncle, whatever immediate family member, to be able to operate their boat while they're not on the water. How many family members would they be able to deem as their, we're not calling it co-captain, right? What was the word?
So this part of the code is a partner or a co-operator.
Partner or co-operator. How many of those can they have designated under this code?
2.
2. Okay, so I guess that leads me to ask this question then. What happens if there's a fisherman who doesn't have any family? Are they now at a disadvantage from those who do have family members who can utilize this code? Because remember, they're all under the same quota, and if we have fishermen who have 1 or 2 co-operators who can be out on the water even when they're not, and then you have fishermen who, let's say, get sick, they can't have someone on their boat. To me, this is a disproportionate.
They could designate so that scenario, they could designate a co-captain, they could hire helpers.
Right, but they
This
gotta be
was-
on the vessel.
Not for the co-captain situation.
No.
That's
Oh.
a different code section. So this was originally, and we haven't, so maybe we should have workshopped this. I would actually recommend that we get rid of this section, but that's not how the committee went forward with it. Because this was originally set up where we could have like you and I could go as partners and create like a partnership, an LLC, for lack of a better word, of a fishing operation, and as long as we were tribal members, like we could create this operation together and go forward. We hadn't really done that in decades. That code provision was not being utilized, and it was flagged at some point, and I recommended originally, we should probably just strike this. We're not currently using it. But then the conversation at the committee level evolved into, well, maybe there are reasons that we need to still have this in, but we'll limit it to being family members. So family members can go into partnership and create this co-operator agreement.
Which would allow them to be in the vessel though, right? Without the captain available. I'm drawing a blank here on what the difference is between this and the co-captains. And this is just, okay, this is just whenever I don't want to go out on the water, my brother, sister, aunt, uncle can.
This is to basically allow, I have my license, and you and I are brothers, and I want to bring you into my operation, but not as a helper. I want you to be an equal partner in my fishing operation, but we don't have a license available. You can't have your own license. So I create a partnership with you where you and I split our business 50-50, but you're operating under my license. That's what this sets up the potentiality for. That's what this would do. That's what this would do. And it's currently allowed in our code, even though no one's done it recently, for me to create a partnership. Me and Dan Doyle, we're not brothers. We're not. I mean, we just.
Well, if we're going to do it for
partnership.
family members, I think we should do it for that situation too, because there's fishermen who don't have family that fish, and maybe they want to have the same benefit. So I'm not comfortable with this, just to be frank. It seems like we're setting up, people in certain situations to have a benefit that others in situations aren't going to have. And so I think that we either just clarify that you can have a partner that's a tribal member, a member of the Sioux tribe, or we just keep it the same as it is right now. I'm not okay with, setting certain parameters around partnerships or co-operators when we have fishermen who have family members who can do it, and then we have fishermen who don't have family members that can do it. So I just think it should be Sioux Tribe member, can be your co-operator, your partner, or we just keep it the way it is.
Larry?
I think the purpose of this was to have people not buy a license and start a partnership with just anybody they want. That's why we eliminated the co-captains. This is allowing your family member to get on the water. We're always talking about giving people opportunities. And what better way to start than, for me, I don't have a son. I do have a daughter, but she's not going to be a fisherwoman. But I have a nephew that wants to take over the boat someday. So this gives him the opportunity. Him and I won't see eye to eye, for starters. I'll step off the boat, he can take the boat out, and he can do it his way. I think this was designed so certain people couldn't buy the license. Say Rob buys a license and says, hey, Ryan, I got a license, we're not related, you just go do it, and we can do it because it's a co-captain, and you could buy 5 or 6 licenses or keep it in your family, and you could keep expanding the business. This is not what we want. We want to limit that, but yet we still want people to have the opportunity to take a boat out and fish.
Good, Larry. Okay, Bridget, then Clarence.
Can I yield to Clarence, because I can see he's really frustrated?
Yeah, go ahead, Clarence.
I better turn my camera off here. Sorry about that if I'm looking frustrated, but, so this stems from a father and son contacted me originally a couple months ago. The son has the license, they fish together. Whenever they can, they're out there fishing together. They were in an area where they were catching some pretty decent catches of whitefish. The son has a full-time job. So there were days when the son had to go to his job where the father could be out there with a helper. They had another helper. The father could be out there piloting the boat to fish and continue to catch a decent catch of whitefish. But he could not because his name is not on the license. Only the son's name is on the license. While he's away at work, the boat's idle. It's on shore. So that's where this stems from. So I looked at the code and I found that this was in there, and I believe Boo King and Larry would know more because he knows the history more of the Kings. That this was in place at one time between a couple of brothers, as was described earlier. 2 brothers in the same situation. One was working, and so when they had the name of both names on a license, so that they could have that situation. One's away, the boat can still be out fishing with a helper. So that's where this stems from. And I mean, as far as fairness, I mean, I don't know if you can't find a father, mother, son, daughter, brother, sister, grandparent, grandson, granddaughter, nephew, or niece, then you're the last one in the line, probably. I mean, I don't. So anyway, sorry about looking frustrated. I guess I might have been, but yeah, I don't think it's grown legs become way more complicated than it needs to be. So I'll shut up. Thank you.
Back to you, Bridget.
Yeah, thank you. I guess I might throw a wrench in it too. The way I feel personally about it is the commercial captain is running his own business, and I understand that we put rules in place, but in my personal opinion, I think that, say you've had a helper that's been on your boat for 10 years and, you know, you, in the evening, you decide for whatever reason something could have happened, that you're not going to be able to go out in the morning. And you should be able to call that helper and say, hey, can you captain the boat? So 1, my business continues to operate. 2, those helpers are still getting paid that rely on that income. You know, I didn't support getting rid of the co-captains, and I know that's, you know, how we got to this point. But I still think it is their personal business. They're making a livelihood, and so are those helpers on the boats. And I kind of agree with Rob. There's probably people out there that don't have those family to pass it on to. So what's wrong with even a helper that's been on your boat for, I mean, I guess it doesn't matter the length of time, but why shouldn't they? Why should they have to call law enforcement and say, you know, you have this illness or whatever, you should be able to say, hey, something's coming up and I'm gonna hit the road for a few days, can you run my boat? That's all.
Okay, anyone else? Rob?
I 100% agree with Bridget. And I understand what Clarence is saying too, but here's the thing, it was provided, this is developed to, you know, pass from family member to family member as a co-operator, but then again, if I have a brother, son, cousin, aunt, uncle, whoever in my immediate family that can operate my boat in my absence, and that's what this code does, that means my boat can be out there making money and my helpers can be making money every single day. Let's say Kim is a commercial fisherman. She's got a boat, but she don't have a family member that can do it. I'm now at an advantage over her, and I don't think that's right. So I think we do it where it benefits all fishermen, or we don't do it at all. I think that, I agree with Bridget, if your helper can man that boat and you're comfortable with it, you can make that call as a fisherman. I think that we need to go in that direction because, you know, like the example I just used, let's say I could have someone on my boat every single day and, you know, let's say something goes on and Kim's also a fisherman and she can't have someone on her boat. I'm now at an advantage, and someday when that quota's met, and I had someone on that water every day, every one of my people are paid and good, hers might not be. So I'm, you know, there's not much more I can say that it's going to be what it's going to be, but I'll vote the way I vote.
Anyone else? All right, let's move on to the next resolution then. That would be Intertribal Software Contract Amendment 2, and it's Jamie Moran.
Good afternoon. ACFS bid out a database build project back in 2024. We experienced the cyber attack, which put it on hold until 2026. They originally recommended a server. They are now recommending a cloud, and there's a $6,100 increase to the contract to have it be cloud-based instead of server-based.
Okay, so this is just going to store our data in a cloud, basically, right?
Correct.
Okay, and the advantage of it being in a cloud is if the server's corrupted or if something happens, you still have it, it gets backed up in a data center somewhere.
Correct.
Okay, any questions, comments on this? Okay, thank you, Jamie. We'll move on. Appreciate it. Next resolution would be Sioux Tribe Incorporated Charter Board Appointment Approval. Rachel, are you on right now?
She is not unless she's with Brenda.
Okay, Brenda, can you cover it then?
Yeah, I can cover this. Is Noah on? Noah just popped on. Wonderful.
Yeah, I'm here, Brenda, to cover it.
Wonderful.
So I'm basically asking permission to approve our board slate.
Approve your what?
Brenda?
I believe he may be having some technical difficulties. I apologize. These two resolutions and our board slate, the Vice President, Noah Lesk, and our CEO, Rachel Heckel, did present these to the board at the April 14th board meeting. We're following 6.6, Article 6, Section 6.6 of the corporate charter. The STI board pulled from their repository of interested people. They did the work on this and they made the recommendations to the board, and they're asking the board to approve the appointment of Shiloh Slomsky and Rod Blanchard for terms ending June 30th, 2029.
Okay, I appreciate that. Any questions or comments on these? And these are incumbents. I believe they've done a good job. Completely support them being reappointed. Okay, seeing no hands up, we'll move on then. Amending Chapter 30 Child Welfare Code. This is something we just workshopped. Any further discussion? I don't think it's needed. Okay, so we'll move on from that into new business. Under committee appointments / resignations, we have the following. So for the Elder Subcommittee, Unit 2 in Newberry, Walter Caswell is looking for an appointment. Sandy Osterhout is resigning. Harold Osterhout is resigning. And then on the Health Board, Susan Codwell is seeking an appointment. Any discussion on any of those individuals or the bodies that they're trying to join? Okay, that brings us to board concerns. Does anyone want to talk about their board concerns if they have any right now? Save time. All right, so we will be on recess until 5 o'clock then. All right, see you guys then. There is an effort to add 2 resolutions to tonight's agenda. The first one is Rob's. It would allow us to vote on initiating the secretary election. We need 9 votes. I'm going to ask you guys then, but do you guys want to poll on that right now? Rob's going to request it anyway, so it doesn't matter. Okay, so Aaron's requesting a poll. So this will be regarding waiving rules to add it to tonight's agenda. We need 9 to say yes. If not, it will just be on the next meeting.
Point of information, I thought we were going to do the other poll, too.
Yeah, that's what I was just gonna say.
Well, let's figure out whether or not it's even supported.
Maybe do the first one, do the one about the changing.
I know what I'll do. I'll figure out whether or not they want it on the agenda, and then we'll figure the second part out. So, yes, if you want it added tonight.
Bridget?
Which one, Rob's?
Yes.
No.
Aaron?
Yes.
Larry?
Yes.
Kim Lee?
Yes.
Mike, Kimberly Gravel?
No.
Tyler?
Yes.
Kimberly Hampton?
Yes.
Lana?
Yes.
Isaac? Rob?
Yes.
That's only 8, and you're missing 2 people.
Okay, so you only have 8, so you don't have support to add it. So let's move on to the next resolution. Jessica, you come on up.
Sean is not here, Michael had to leave.
Maria's actually going to present this.
Oh, Maria is, okay, sorry. Yeah, go ahead.
You have
Hi,
2
this
no votes.
will allow the Housing Authority to apply for a $2 million grant from Wells Fargo and Enterprise.
Guys, she's talking.
I'm sorry. It's a housing affordability breakthrough challenge, and the grant is to expand access to quality, affordable housing through an innovative challenge encompassing design, construction, finance, service delivery, and program focus. So we feel it falls in place with our supportive housing project.
So it
We'll
sounds
use-
like there's a grant opportunity and the deadline to apply is nearing and we won't have
15th.
time to place it on the next agenda.
Yes.
Okay, perfect. Any questions, comments on this? Anyone opposed? Aaron?
Do you?
Anyone opposed to adding it to tonight's agenda? Okay, so I don't think there'll be any issues. I'll ask when the meeting begins as well. So anything else we need to go over before 5?
That's all.
All right, recess at 5. right, everyone, it is 5 o'clock, so I'm going to be going ahead and calling this meeting to order. We'll start with roll call, please.
Larry Barbeau.
Here.
Michael McCurchy. Bridget Sorensen.
Here.
Tyler LaPlante.
Here. Here.
Kimberly Hampton.
Here.
Rob McGrory.
Here.
Kimberly Gravel.
Here.
Isaac McKechnie.
Here.
Kimberly Lee.
Here.
Sean Borowitz. Lana Cosley Smith.
Here.
Aaron Paymont.
Here.
Austin Lowe's.
Here. We have a quorum. Any objection to excusing Mike and Sean's absences? Okay, so hearing no objection, both their absences are excused. There's a request to add 2 resolutions to tonight's agenda. I'm going to handle each of those separately. So the first one would be Wells Fargo Enterprise Housing Affordability Breakthrough Challenge. Is there a motion to add that?
Motion.
Motion by Isaac, support by Isaac. Any discussion here? Okay, all those in support signify by saying aye.
Aye.
Those opposed? Those abstaining? Motion carries, and that will be added to the proposed agenda. The second one isn't going to be universally supported, so I'm going to roll call that. It's titled Authorizing Amended Constitution Submission for a Secretary Election. Is there a motion to waive the rules to add that to tonight's agenda? So there's a motion by Rob, support by Aaron. Can you just do the roll call on that, please? And you need 9 to waive the rules to add it to tonight's proposed agenda.
Bridget.
No.
Aaron.
Yes.
Larry.
Yes.
Kimberly Lee.
Yes.
Whoops. Kimberly Gravel. No. Tyler.
Yes.
Okay. Kimberly Hampton.
Yes.
Lana.
Yes.
Isaac.
Yes.
Rob.
Yes.
1, 2, 3, 4, 5. That's still 8. 8 yeses, 2 noes.
So
Lana,
you have
will you-
8 yeses, hold on a second. So that motion dies due to lack of support.
Lana, will you please add that to the next meeting agenda?
So that would be added, and it would be duly noticed, so you guys will have it on the agenda to vote on.
I'll sponsor.
Yeah, so now we're on approval of the agenda. So on tonight's agenda, we have the following items. We have minutes from 4/21 of '26. We have the following resolutions. Inland Fish and Wildlife FY26 budget modification, NRD GLRI capacity FY26 budget mod, Health opioid settlement FY26 budget mod, Health Human Resources FY26 budget mod, Health Manistique Medical FY26 budget mod, Health Marquette Medical FY26 budget mod, Health Marquette Equipment FY26 budget mod, BIA Cares Establish FY26 budget, amending Chapter 20 Commercial Fishing Treaty, amend 2024-399 ACFS Direct Services Database, STI Appointment Approval, Slomsky, STI Approval, Blanchard, amend Chapter 30 Child Welfare Code. We just added Wells Fargo Enterprise Housing Affordability Breakthrough Challenge, and under new business, we have committee appointments/resignations and board concerns.
Support.
Motion from Isaac, support by Larry. Any discussion on the proposed agenda? Hearing none, those in support signify by saying aye. Aye. Those opposed, those abstaining, motion carries and the agenda is adopted, which brings us to our first item, which is invocation with our buddy Gerard from Traditional Medicine.
I'm not going to stand until
Me either.
Just, I get real nervous when people stand and rise. That's why I don't go to church. Just go, are we coming or going? Annie, can you come and help me? Please?
Anytime.
Huh?
Anytime.
Can you come out of retirement and help me? Just kidding. You go first. Now, how about you? I guess one of the things I often reflect on is the loss of life. And there's an elder from across the river, Ted Recollet, and he passed over the other day, and they just wanted to acknowledge him that on this side of the river, because he's came over to help us out a few times and things that we're doing. And I know that in our communities, in the last little while, there's been lots of Passovers as well, to all those ones that might be grieving and mourning. My thoughts of words are out for families. The one thing I was highlighting in my day-to-day was spirit and physical. So when we're brought into the world, that's a physical. And we leave this world, that's a spiritual. And they're both births. But sometimes we look at it from, I guess, from AI, where it's very emotional. So it is. And the same as springtime and the renewal of life, everything coming, the plants are coming, the buds are coming, the spawns are coming. Everything's coming alive. And gas is $7 a gallon, going to be $8 a gallon. So there's going to be hardly any lawns cut this summer. Just kidding. So don't be mad if somebody's hay is not being cropped. But it's to really have that. Anishinaabe have a beautiful gift, and that beautiful gift is to smile and laugh and pick up each other in the hardest of times. And when we see what's happening just in town or on the other side of the creek or down by the other bridge or over the bridge or the other bridge, when we're at home in the beehive, we're pretty medicine-y. The beehive, that's one of the medicines of four when it comes to protection. And the other one, the biggest one, is us as Anishinaabe. Not as chairmen or not as chair people, but as blood relatives or spirit relatives. So quite often I almost get clobbered here because I'm not afraid to speak up for us. When I hear the misgoings on and the misdoings, I'm not afraid to speak up for them. So quite often I end up with a flat tire. But I don't really care, because what it boils down to is, if I don't, who's gonna? And I always say that about wherever it is that when it comes to this, it comes from here. And quite often, sometimes when I leave here, or sometimes when I leave work, I get very emotional at the things that I couldn't control. And it's the individual. And a lot of our health is like that. And I quite often think about, I shared something yesterday, and it's a funny, I hope, but I shared something yesterday. It's like the last little while, some people, they book an appointment, and we're waiting, they don't show up, they don't call. And we call, they have their phones on, they must have caller ID on, and we just phone to see if they're okay. And they still don't call until they need another appointment. But heaven forbids, if we don't show up, it's like they don't follow protocol or they don't follow the guidelines. They go right to the board, or they go right to James or whoever that is, but it's like that. And I really feel for each and every one of you that sit around the table. And I also really feel for each and every one of us that sit around in the community, because it's always like Kim's going to fix it for me, or Austin's going to fix it for me, or somebody's going to fix it for me, right? But when it comes down to it, is right here, where we have to fix it. And so that's why it's easy for me to go take on a bunch of rednecks in the casino at 11 o'clock at night. I'm not afraid to do that when it comes to the derogatory things to the tribe. I get very upset with it because like nobody told me to turn off I-75 to come down here, and they forget that. So I remind them that I'm a guest too, but I don't ever be so critical that it annoys me, because it takes a lot to annoy me. Naha bonjour. Misagoya magi mamagain no nigakid week mamagay kanishna bayin the bajgoying mamagain is zigwan mamagain minuya bamadzigi ayik mamagain to get the gagon mamagain to get the goyayik mamagain get the gagos. Get the goggles is that little female there, deer, and Niabe is that little buck, that little male deer. Mige winigin unda wiya kig, mabige nunda sagoyan in, mabige ginishnabe. Mabige zina get the gon, kinige winigin unda sagoyan, mabige nishkiki is that garden of medicine. Mige winigin undas goyanage in mishkundan is like kind of standing strong or standing the best that we can in the presence. Minugoi win on it, Mobigan Wabanong, we gave Shamanong, Garnigabio Dunk, Kinege Winigi in those doorways and all those medicines in those doorways. And the Shomus, Mobiga Gokamis, we give them at Biak, it's those grandmothers that look up to those doorways. And to all those dodemwi and all those animals that sit in those doorways. Winigin undagik, mabigagin undas goyana, mabiginish biming. Mabigay winigin undas goya, megizik, kinigay winigin unda bamajin, kinigay winigin undas go was goyan, and up higher than the sky. Was niya ishbiming. Mabagain we are kig. Mam Shagoyanigin Majayik, Bomage Kinige Winigin on is that they're gone home in that place. And Mampin Nongoyang is here we are as one. And sometimes we need to remember that up there. Not just on October 31st or November 1st, but quite often. Way ya ya, way ya, way ya ya ya, way ya, oh way ya, way ya ya, way ya ya, way ya oh way ya ya, oh way ya ya. Anishna beniganda, Anishna bega we manda, we ge mabinda, the enda gega mabinda, and ayagne mampi gigandanda ne yam. Kenaya nigagmin goya, Kenaya nigimin ya, mage gondo, ma bendane, ba mansege, ba mansen non bagen, we magen in dom. The mansen and we gone in again. It's like being healthy and thinking healthy and living healthy with love. Miigwech.
Thank you so much, Gerard. Appreciate you. Next item that we're on is membership participation. So those of you in attendance have the right to address the Sioux Tribe Board of Directors. When you do, we limit it to 5 minutes. Handful of really common sense rules: no yelling, no swearing, no singling out individual board members, no attacks, anything of that nature. If things are confidential, if they should be confidential, I'm going to put you in closed. It's not to punish you. It's just there's certain topics that, you know, thousands of tribal members online really shouldn't watch. A lot of matters are private between the tribe and an individual. So with that, if you guys want to talk to us, this is Michelle Moore. She has membership participation forms. Raise your hand, fill one out, and we'll get you up here. Okay. Jackie, would you like to come up first?
Ani Bojo, Jackie Minton, Nadision Cause. Today we are here with the Kinross and Rudyard Tribal Youth Council. We came before the board probably about 6 weeks ago and went into closed session to ask for funding for the returning of the Thunder's powwow. And so we are just here to acknowledge that funding, so we'll turn it over to one of our Tribal Youth Council members.
Ani Bojo. My name is Charlie Badger, and I'm here representing the Kinross and Rudyard Tribal Youth Council. We would like to say miigwech for donating the money in order for us to get the powwow and for everyone to be able to experience that. We have reconciled the funding and forwarded it to YEA last week. Again, miigwech for your support to our endeavors, and we hope to see you next spring when we have our powwow again at the Rudyard area schools. I'm sorry, miigwech. You're great. Miigwech.
Okay, thank you so much. Appreciate you guys being here. Okay, next up, let's see here. The next 3 will be closed, so if all you guys can leave except David, we'll handle this one closed. We have concluded membership participation, which brings us to our actionable items. The first are minutes from 4/21 of 26. I'd like to entertain a motion to accept them. Motion from Isaac, support by Larry. Any discussion on these minutes? Hearing none, those in support signify by saying aye. Aye. Those opposed? Those abstaining? Motion carries and those minutes are adopted. That brings us to resolutions. The first one is titled Inland Fish and Wildlife FY26 Budget Modification.
Be it resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the FY 2026 budget modification for inland fish and wildlife for an increase in other revenue of $525, changes to the personnel sheet, and reallocation of expenses, no effect on tribal support.
Motion by Isaac, supported by Larry. Danny, could you explain this resolution to our membership, please?
Yep. Hi, everyone. These were workshopped last week by Katie Schultz and the second one by Brandy MacArthur. I'll be presenting both tonight. This budget is for 4490. This is our rights protection implementation BIA funding. And we needed to shift some staff time onto different grant-funded cost centers, as well as move some funding into assessment lines for the purchase of safety supplies, preventative maintenance, office supplies, and space cost for the new building.
Okay, I appreciate it. Any questions, comments from the board? Hearing none, those in support signify by saying aye. Aye. Those opposed? Those abstaining? Motion carries. The next resolution is NRD GLRI Capacity FY26 Budget Modification.
Be it resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the FY 2026 budget modification for GLRI, distinct tribal program capacity for changes to the personnel sheet, page, and reallocation of expenses. No effect on tribal support.
Support.
Motion from Isaac, support by Larry. Danny?
This is similar in that we're doing a bit of housekeeping and reallocating where staff are paid from. Some of the staffing that was changed on 4490 is reflected in the inverse change on this cost center. And we also needed to move, at the recommendation of our accounts and budgets, move some funding from the computer line into more appropriate lines like miscellaneous assessment, office supplies, and small tools and equipment.
Okay, appreciate that. Any questions, comments from the board? Hearing none, those in support signify by saying aye.
Aye.
Those opposed? Those abstaining? Motion carries.
Thank you.
Thanks, Danny. The next resolution is Health Opioid Settlement FY26 Budget Modification.
Be it resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the establishment of an FY 2026 budget for State of Michigan opioid settlement with State of Michigan revenue of $538,461.
Support.
Motion by Isaac, support by Larry. Annie?
Yes, this funding source that we received from the state of Michigan, we workshopped it last week. It is the tribal opioid settlement funds, and we're going to, it does need to be spent by 9/30/26, but we've already been working on it. We're ready to pull the trigger as soon as you approve the budget.
Awesome, happy to hear it. Any questions, comments? Lana?
Yeah, when we workshopped it, Annie, I had asked, and maybe it was sent, I'm not sure. If it was, I missed it, but I had asked for what the budget was for this and what you guys were going to increase and put together for spending out this money.
Yes, so there's $538,461. There's going to be some funding spent on consulting and contracting. We want to contract somebody to review our current TAP and update it. There's also some supplies for traditional medicine, travel and training for some training. There's some honorariums in there. There's equipment, and we plan on buying 2 transportation vehicles to assist the community going back and forth to recovery services.
Okay. So, do you have the budget in front of you?
I do.
So the direct service line item, the money that's going to go to reduce barriers to the member, how much is that? And it's not attached, or I'd just look.
Right. Which line is it?
The direct service?
That, I believe that is the RHTP program that we haven't been awarded yet. Unless,
No, well, this says in the reduce barriers related to opioid and substance abuse. So,
Okay,
you
yes,
talked about consulting and travel and
Yes.
things like that, and,
transitional housing, taxi tokens, inpatient care,
so
a
most of that's
de-stigma.
probably in a direct, okay.
Yes.
That's what I'm getting at,
Yep.
thank you.
Yeah, sorry about that.
That's okay.
Anyone else? Okay, hearing none, roll call, please.
Bridget,
Yes.
Aaron,
Yes.
Larry,
Yes.
Kimberly Lee,
Yes.
Kimberly Gravel,
Yes.
Tyler,
Yes.
Kimberly Hampton,
Yes.
Lana,
Yes.
Isaac,
Yes.
Rob.
Yes.
Motion carries. Thank you.
Thank you.
The next resolution is Health, Human Resources, FY26 budget modification.
Be it resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the FY 2026 budget modification for human resources for a change to the personnel page.
Motion.
Support?
Motion by Isaac, support by Larry. Go ahead. Oh, you just got to use your microphone, though. Sorry about that, Karen. You just got to press it so it's green.
All right. I would like to respectfully ask the Board of Directors to approve this budget modification. This budget mod is changing the title of HR Administrative Assistant to HR Employment Specialist. There will be an increase in wages and salaries of $3,109.04. This will not affect the 2026 budget due to current vacancies. There will be no effect on tribal support.
Okay, thank you. Board discussion, start with Bridget.
Karen, is this going to be posted?
No, it was on already.
Yeah.
You just turned it off.
As long as it's green.
You don't have to hold it.
Yeah.
Okay. It can be posted, but it wouldn't have to be posted, as this person who is the administrative assistant currently is a tribal member. So according to policy, I could send an email to everyone in my department, ask all of them if they're interested, and go about it that way, or I could post it for 3 days in-house. Correct.
Do you know what the plan is, if you're going to be promoting someone internally or posting it?
Promoting someone internally.
Okay, well, that's awesome when we're able to do that. So, anyone else?
Guess I couldn't finish.
Do you have anything else to say, Bridget? I didn't think so. Anyone else? Okay, roll call, please.
Kimberly Hampton,
Yes.
Tyler,
Yes.
Rob,
Yes.
Kimberly Lee,
Yes.
Isaac,
Yes.
Lana,
No.
Larry,
Yes.
Bridget,
No.
Kimberly Gravel,
No.
Yes.
1, 2, 3, okay.
Motion carries. Thank you, Karen. The next resolution would be Health Manistique Medical FY26 budget modification.
Be it resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the FY 2026 budget modification for Manistique Medical Nursing for a change to the personnel page.
Motion.
Support?
Okay, motion from Isaac, support by Larry. Nikki, could you present this for us, please?
Yes, hi. This budget mod respectfully requests to add the position of a certified medical assistant to the personnel page to take the place. We have had a vacant LPN position with no interested applicants, and we're just trying to get the clinic fully staffed. So this would kind of take the place of the LPN here and make us fully staffed.
Yep, much
There's-
appreciated. Any questions, comments from the board? Okay, those in support signify by saying aye.
Aye.
Those opposed? Those abstaining? Motion carries. Thank you.
Thank you.
The next resolution is Health Marquette Medical FY26 budget modification.
Be it resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the FY 2026 budget modification for Marquette Medical Nursing for changes to the personnel page and reallocation of expenses.
Motion.
Support?
Okay, motion by Isaac, support by Larry. Marlene, or I think Marlene's going to be presenting on this. Go ahead, Marlene.
I'm here. Can you hear me?
Yes, we can. How you doing?
Thank you. I'm good. Thank you. Yes, this budget modification also moves medical assistant 1 to a medical assistant 2 position for the Marquette site. We did interview a qualified applicant. We're just hoping for board approval so that we can offer the position. And once 2 weeks' notice has been given, we can hire this person and get this clinic in Marquette going.
Okay, I
Thank you.
appreciate it. Any more questions, comments from anyone on this? I apologize if I cut you off, Marlene. When I don't see someone on Zoom, it's hard to tell when they're done speaking and when they're not.
That's okay, thank you.
Okay, any questions, comments from the board? Okay, hearing none, those in support signify by saying aye.
Aye.
Those opposed? Those abstaining, motion carries. Thank you, Marlene.
Thank you.
The next resolution is Health Marquette Equipment FY26 budget modification.
Be it resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the establishment of an FY 2026 budget for Marquette Equipment with federal IHS revenue of $167,601, no effect on tribal support.
Motion.
Motion by Isaac.
Support.
Support by Larry. This one's going to be covered by Marlene as well.
Yes, this is the initial award. The initial award of this Indian Health Service equipment funds from, was for this new site. It was originally $241,848. We spent $74,000. Actually, up to now, we've spent about $104,000. And we will spend the balance very quickly so that this is spent by the end of September for the rest of the equipment needed for this new site.
Okay, thank you so much, Marlene. Appreciate the explanation. Any questions or comments from the board on this resolution? Okay, seeing no hands coming up, roll call, please.
Kimberly Gravel.
Yes.
Kimberly Hampton.
Yes.
Lana.
Yes.
Bridget.
Yes.
Rob.
Yes.
Larry.
Yes.
Kimberly Lee.
Yes.
Tyler.
Yes.
Aaron.
Yes.
Isaac.
Yes.
Okay, thank you. Motion carries. The next
Thank
resolution
you
is.
so much.
Thank you. Is BIA Cares Establish FY26 Budget.
Be it resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby approves the establishment of an FY 2026 budget for BIA Cares with federal BIA revenue of $858,920.23.
Motion.
Motion by Isaac, support by Larry. Holly?
What this resolution will do is it will establish a budget for $858,920.23. It will refund previously appropriated tribal support into 6 different budgets, and it will allocate out that same amount of BIA CARES funds that we had remaining.
Thank you, Holly. Any questions or comments from the board? All right, hearing none, roll call, please.
Kimberly Gravel.
Yes.
Aaron.
Yes.
Tyler.
Yes.
Bridget.
Yes.
Isaac.
Yes.
Lana.
Yes.
Rob.
Yes.
Kimberly Lee.
Yes.
Kimberly Hampton.
Yes.
Larry.
Yes.
Motion carries. Thank you, Holly.
Thank you.
The next resolution is amending Chapter 20, Commercial Fishing Treaty.
Now therefore be resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians hereby amends Tribal Code Chapter 20, Great Lakes and St. Mary's River Treaty Fishing Regulations to the following. 20.102, licensing of commercial treaty fishing activities. 6, a commercial fishing license may identify 2 tribal family members as partners and co-operators of a licensed boat. For this section, family member shall mean father, mother, son, daughter, brother, sister, grandparent, grandson, granddaughter, nephew, or niece. Be it finally resolved that this resolution shall be effective immediately.
Now a motion.
Okay, motion by Larry,
Support.
support by Kim. Clarence, could you explain this resolution to our membership, please?
Sure. So the current language in the code allows for 2 names on 1 license in a partnership situation. The Conservation Committee talked it over and decided to clarify it, to tighten it to include just family members. And the family members are listed in the resolution, the code language. So if the majority board feels as Director McCrory and Director Sorensen did earlier, well, I guess nothing has to be done because it would cover both the father and son partnership that we spoke about at the review and also the captain that has a helper that's been with them 10 years. I mean, so it's whatever the board decides to do on it. And I guess I should also say too that I learned something about myself earlier today, that it's much easier for me to keep a poker face than personal setting than it is on a Zoom call, so. But that's where we're at with it, so.
Thank you, Clarence. Board discussion, start with Isaac, then Aaron.
Clarence, what was the vote count?
It was, I believe, unanimous, except for there was one abstention.
Okay, thank you.
Aaron.
Yep.
Yeah, and when I was at the committee meeting when they discussed it, and I supported adding the additional family member names because, I know in our family, if I would have had that opportunity, I probably would have tried to retain our license, and my brother let it go back. But I think if I would have been able to be a co-partner like this is doing, brothers, I would have gotten the license. I probably wouldn't have fished very much, I'll be honest about that. But I supported that, so, thanks.
Okay, anyone else? Bridget, then Rob.
Well, just like we discussed in the workshop, I am in support of this, but I'm also in support of, like I said, if there's any current helper on your boat and for whatever reason you make a call that night and say, I can't make it, that way your boat, it's your personal business, so that continues to operate as well as your staff can get paid by going out. So I'd like to make a motion to amend to any current helper as well.
Support.
So there's a motion to amend this to include any helper. We'll start a discussion, but what I will say is you should probably have the Natural Resource Division's input in this because it will increase the amount of boats that are on the water. If someone can't have their boat on their water, it'll create an opportunity where they can, and it may have an impact on the resource. It may be in your best interest to hear what they have to say about this issue. It's up to you guys, though. So who wants to speak on this? Rob?
Well, would it increase the amount of boats? Because I think the license would only go to one vessel, right?
It would, yeah, per our conversation earlier, but let's say you have a health issue and you can only be out on the water half the time. You have an immediate family member that boats out all the time, puts additional stress on the resource, and creates the possibility where the fisheries would have to be shut down because you've reached the quota.
Okay, so that's my exact point. Under this, it would allow the example I used earlier. Let's say I am a commercial fisherman and I have a son, a nephew, a niece, a brother, sister that can make it so my boat is out on the water at all times. This would allow that. But let's say Kim is also a commercial fisher and she doesn't have that. That would put me at an advantage over her, and when we're all working towards the same quota, I don't think that would be a fair advantage for me to have in that situation. So I support someone in a position where they prefer their nephew or their son or aunt or uncle or brother or sister to be able to take over the boat. But I also want someone, like in the example I just used, for someone, let's say Kim was a fisherman and didn't have that. We need to make it so that that's fair for someone in that situation, because under this code, it sounds like it would allow one boat to be out all the time based on a family member being on it, and then another fisherman who might not have a family member, they wouldn't have that same option. So I'm in support of this if we could make it fair, but I don't see this one as fair. If we have one fisherman with a family member who can take over a vessel, and that boat's out on the water at all times, yet we have another fisherman who doesn't have that same luxury. So it puts one at an advantage over the other. I'm okay with having the boat on the water at all times because when it comes down to it, we're meeting the same quota. When we get close to it, you as the chairman have to shut down the fisheries if that's the case. Hopefully we don't get to that point, but that's the reality of it. So it's placing one vessel at an advantage over another vessel just based on them having a family member that could fish it. And I'm not really okay with that.
Okay, Isaac, so at some point, what I would recommend is that someone motion to table this. We haven't workshopped this. We have natural resources here. We have conservation committee here. And we talk about this, talk about the potential impacts to the fishery. We go through it. So just my recommendation. Isaac?
So I'll make that motion after I finish speaking. Hey, Clarence, I just want to know your opinion and if the committee has reviewed Rob and Bridget's request, because why have a committee if we're not going to let them even give us input, so.
Okay. Well, as I said earlier, I mean, if that's the pleasure of the board, that nothing has to be done because the language, maybe legal should weigh in on it, but as I understand it, as I read it, the current language allows for that.
Correct.
The current language it says two names as partners.
Wow.
So
That's correct.
That's what it says.
So that's
So-
what it is, so it's a moot point, really.
If instead of amending it, I guess you would just not vote on it, and it would go back to that, and that covers both situations that Robin, or Director McCrory and Director Sorensen are speaking of.
I'm good.
Okay, anyone else? Aaron?
I'll motion to the table, because I do think we should go back to the committee and get their input.
Yes.
Okay, so there's a motion to table. Is there a second?
Support.
All right, so there's a motion by Aaron, supported by Isaac to table, suspends debate. Roll call, please.
Isaac,
Yes.
Larry,
No.
Tyler,
Yes.
Kimberly Gravel,
No.
Lana,
No.
Bridget,
No.
Aaron,
Yes.
Kimberly Hampton,
No.
Rob,
No.
Kimberly Lee.
Yes.
You got 4 yeses, 6 noes.
Okay, so motion to table fails. We're back on the motion to amend. Any further discussion?
Can I
Karen?
withdraw my motion?
You can die due to lack of support when we vote on it. Go ahead, Aaron.
So, all right, so we're not under the old decree anymore, but it's still our responsibility to have a conservationist approach to our fisheries. There isn't an unlimited amount of fish on the waters. I supported, and I do support, the expansion for the family members, but I don't support just any helper being able to step into that role, because by limiting it to the family members, you're limiting how many people are gonna be on the water to who has a vested interest in that business, which is the family. Now, of course, helpers also have a vested interest, but I think that's gonna create a racehorse fisheries and a volume of fishing activity that I don't think is responsible. So I don't think that that's the right approach, but I did very strongly support at the committee level, because when they were just debating it, they were unclear whether or not the board would consider that. And I didn't speak for the board, but I said, yeah, I think that's reasonable. So, but it's not reasonable to have it open for a helper to step up as the captain. I don't support that. So I'll vote no on that, but I will support the family members being able to step in, and it lists out almost any kind of relative that you can think of, so they're gonna be able to fish that, so, thanks.
Okay, who else do I have over here? So Larry, go ahead.
In my opinion, if we go Rob's way, we're turning into a co-captain again, and that's something we're trying to get away from.
The issue is, though, if you don't have any immediate family member that are willing to work for your commercial fishing operation, it puts those operations at a disadvantage. You know, I think that's what his argument is about. But the counter argument is that co-captains were done away with because it put a lot of pressure on the fisheries and then it was closed. So it's gonna be the same situation. We can get as many boats as we want out on the water, but we're only allowed to catch so much, and once we reach that, it's getting shut down for the season. So it just is what it is. So does anyone oppose to Bridget rescinding that resolution to motion to amend this? No? Okay. All right, so we'll just vote on it, all right? So,
It's the original.
no.
Request for permission to withdraw or modify a motion. She can, as long as nobody objects, that's all.
And we
you gotta
just
do.
have an objection?
No, I didn't.
Oh, I thought you said you objected. Okay, does anyone object to that? Okay, so this is the motion to amend to allow any helper to be able to have commercial fishing rights if the license holder isn't there. So it reverts it back to it has to be a family member. Keep your hands down for a second. Does anyone object to that? Okay, so we're done with that motion. We're back on the main one. Speakers list consists of Kim Lee. Does anyone else want to speak on this? Okay, go ahead, Kim.
Yeah, I really wish we could have tabled it to have a further discussion, but what if we switched it all to one? Allowing everybody to have one, whether that be a helper or relative, and that would bring down those numbers a little bit and
Let them have what?
limit, so one partner or co-operator versus two. And then that would limit the number of, I guess, people that were out, that could be out on the water at one time. Again, I wish we could have tabled it so we could discuss it with committee as well as natural resources, but if we could consider something different to make it work for everybody.
Okay, Aaron?
So this is what the committee's requesting. I'd like to call for the question.
Okay, so there's a motion to call for this question. Is there a second?
Second.
Okay, so we'll roll call the question. I think we have to pause the majority on that. And this will suspend debate and cause us to vote.
Anybody on the list?
No,
No?
should be easy. You can ask without objection, Mr. Chair.
Does anyone object? Okay, okay, so we have an objection. So motion and a second, call the question. Roll call, please.
Kimberly Lee.
No.
Isaac.
Yes.
Kimberly Hampton.
Yes.
Rob.
No.
Bridget.
Yeah.
Aaron.
Yes.
Tyler.
No.
Lana.
This is to call for the vote.
Yes.
No. No.
Larry.
Yes.
Kimberly Gravel.
Yes.
6 yeses, 4 noes.
6 yeses, 4 noes, fails, but, you know, gee whiz, we don't have anyone else left on the speakers list. Oh, Rob, go ahead, Rob.
I just want a little more clarification from Clarence because,
Well, we called the question. It was approved.
no, it wasn't.
Wasn't.
I
It's not a
object- I
simple
objected and we
majority.
just roll call voted it.
I'm sorry. Okay.
No, I just want a little bit of clarification here because it was stated if Bridget and I's, our point was to be held to that standard, then nothing would need to happen. So right now, does that mean someone can allow a helper or someone to man their boat while they're not on it?
They can get a co-captain if they have a medical reason.
Rob, right now, that's true, what Aaron said, but also right now in the code, you can assign under your captain license up to 2 partners or co-operators. Does not have to be family right now. This change was intended to limit who could be a partner or a co-operator to the listed family members. Right now, we have the ability as commercial captains to list up to 2 partners right now on our operator.
Or a co-operator, right?
Or a co-operator.
So let's say, so this code would change it to, let's say, I'm captain. I don't want to go out the next day. I can have a co-operator go out and fish the next day under my license. And right now, that can happen.
Right now, that can happen per our code, correct.
Okay, so this doesn't take away anyone's rights. And really, if we vote yes on this, we're only narrowing the scope to people who have family members who can man the boat.
That's correct.
So if I'm to vote no on this, I'm not taking anyone's right away. I'm just voting no to narrowing the scope to where only family members can do it.
That is correct.
Point of
Thank you.
information. I'm getting a little bit confused. So, right now, if we have a co-operator, they can man that boat right now without a medical reason. I thought it was supposed to be a medical reason for them
We
to.
have two things happening. We have co-captains,
Right?
which we don't generally do, but we do them in case there's a medical need. We have this language in our code that has not been triggered for many, 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 many years. My recommendation to the committee was get rid of it. It's obsolete. We don't do this anymore. The answer to the committee was maybe we want to do this going forward for family members for having a partner in my operation. And that's the short version of how we got here today. But the co-captain thing is entirely different. It's part of the code, even though sometimes they can operate in a similar way.
So even though you said that the code is obsolete because we don't use it, the code still says that we can do it. So if we do nothing, 2 co-operators can get on that boat right now anyways, and that's
correct.
exactly what they're talking about.
That is correct.
So, yeah, so with this, we are really limiting it to just family members and no cooperators.
Yes, that is correct, Lana.
Right, family members,
That is
yeah.
correct. This would limit partners and cooperators to being just those named family members. Right now, it could be any tribal member who I name on my license. Even though we haven't done that recently, it's still on the books, it's still a tribal law, and we have the ability as commercial captains to do that, to do Rob's scenario that he's talking about.
Right, I just don't understand how we can say we got a code in place and it's obsolete because we never used it. That's not obsolete, that means we don't practice it, and people are told they don't get to practice it. Right?
Okay, maybe that was a poor word choice on my part, but because we haven't done it in 15 or so years, it was a code provision that I think most of the functionality is covered under helpers and co-captains. And so my recommendation was we should talk about whether we need this provision or not. Conservation Committee says we need it with sideboards. The board's talking tonight, maybe we need it with no sideboards. Just leave it as is.
This is why we tried to table it, you guys, so we could have this conversation on at 5. So I have Kim Gravel, and then Lana, if you want to speak again. So I have Kim Gravel, Bridget, Larry.
Okay. I don't think we need to get rid of it because it doesn't sound like it's being abused, but it's there if we need it. And this is just making it more restrictive, and we don't want to do that. Correct? That's what I'm getting from most of the comments.
Yeah, you're right.
Okay. Yeah, because the way I was getting it, I almost felt like it was being abused, and that's why we were making it more
I
restrictive.
think the biggest reason why, as committee members on the Conservation Committee, is we saw what happened at a certain spot by a certain fisherman that was buying licenses and handing them out, so they had a whole bunch of boats on the water, as people were saying, getting close to the tack. So if we limit it to one boat, but have a couple of operators on it, now we got a chance to fish all season instead of closing down the waters. In 2015, I believe, we had to close down the waters because we got too
remember.
close to the tack because there's too many co-captains out there fishing.
So, but that hasn't been happening, or that is happening again?
Ever since we got rid of the co-captains, it hasn't been
Hasn't?
happening.
It hasn't happened because they took away co-captains, so it's still embedded in code. However, it's not standard operating procedure to issue those licenses anymore. So they want licenses, well, not licenses, they want the ability for other people to fish on the boats. It's just they've been told that we've moved away from having co-captains.
Right.
So they pivoted and said, well, what about just an immediate family member? But per Rob's point and your point too, it sounds like it does limit who can operate those boats. So if I don't have any immediate family members or anything like that that have ever worked for me
Wow.
that know how to operate my boat, I'm out of luck. Whereas if Rob has an operation and he's got 10 kids and they all help him out, then it kind of gives him a competitive advantage over me. So that's part of the issue we're talking about.
Okay.
So if we want to issue co-captains licenses again, we can, but you're going to have more pressure out on the water. So, Bridget.
I think we need a little more discussion, so now I would vote to table it. I would
Okay.
support it.
Motion to table, supported by Aaron Paymont. Roll call, please.
Ole.
Kim Gravel,
No.
Kimberly Hampton,
Yep.
Lana,
Yes.
Bridget,
Yes.
Rob,
No.
Larry,
No.
Kimberly Lee,
Yes.
Tyler. No. Aaron,
Yes.
Isaac,
Yes.
6-4.
Okay, motion to table carries. That moves us to the next resolution, which is titled Amend 2024-399 ACFS Direct Service Database.
Now therefore be resolved that the Board of Directors of the Sault Ste. Marie Tribe of Chippewa Indians amends Resolution 2024-399 to cover the increased project costs of $46,915, funded from Cost Center 13181. Be it further resolved that the Board of Directors hereby authorizes the chairman of the tribe or their designee to execute any and all documents necessary and appropriate to carry out the terms, conditions, intent, and administration of this resolution. Be it finally resolved, the Board of Directors authorizes the governmental CFO and CEO to perform any administrative budget modifications necessary to carry out the intent of this resolution.
Motion.
Motion by Isaac. Support by Larry. Jamie, you can
Annie
cover this, please.
Boujou, Jamie Moran, Anishinaabe Community and Family Services Director. We're before you tonight respectfully requesting authorization to amend a prior resolution to allow ACFS to obtain a database for the direct services programs. Previously, when we got the bid in 2024, the recommendation at that time was for a server. That recommendation has since changed to instead be cloud-based, which resulted in an increase of $6,100.
Okay, thank you, Jamie. Any questions, comments from the board on this? Okay, hearing none, those in support signify by saying aye.
Aye.
Those opposed? Those abstaining? Motion carries. Thanks, Jamie.
Miigwech.
Yep, have a good night. Next resolution is STI appointment approval, Slomsky.
Be it resolved that the Board of Directors for the Sault Ste. Marie Tribe of Chippewa Indians pursuant to Article 7, Article 6, Section 6.6 of the Sioux Tribe Corporate Charter hereby appoints the following individual to the Corporate Board of Directors of Sioux Tribe Incorporated to serve a 3-year term as specified below. Shiloh Slomsky for a term expiring June 30th, 2029.
Motion.
Motion by Isaac, support by Larry. Rachel, could you explain this resolution? It's essentially to replace, or to reappoint an STI member.
Yes, absolutely. So this and the following resolutions are both to reappoint our current board members to the Sioux Tribe Incorporated Corporate Board. They have both provided exemplary service in past time, and for continuity of the business and what they provide, we'd like to continue with their support as board members.
Thank you. Any questions or comments from the board? Hearing none, those in support signify by saying aye.
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 Those opposed? Those abstaining? Motion carries. That brings us to the next STI resolution, which is titled STI Appointment Approval, Blanchard.
Be it resolved that the Board of Directors for the Sault Ste. Marie Tribe of Chippewa Indians pursuant to Article 6, Section 6.6 of the Sioux Tribe Corporate Charter hereby appoints the following individual to the Corporate Board of Directors of Sioux Tribe Incorporated to serve a 3-year term as specified below. Roderick Blanchard for a term expiring June 30th, 2029.
Motion.
Motion by Isaac, support by Larry. Rachel, could you cover this one as well?
Absolutely. Similarly, Rod Blanchard has been serving as our chairman of the board for past several years. His experience both with the Customs and Border Protection on the government side, working with contractors, provides valuable support, as well as simply his continuity. He's provided great support for us, and we'd like to continue on with his appointment with the board.
Yep, he's doing a great job. Any questions, comments? Hearing none, those in support signify by saying aye.
Aye.
Those abstaining? Those opposed? Motion carries. Thank you. The next resolution is amend Chapter 30, Child Welfare Code.
Now therefore be resolved that the board hereby authorizes and approves the above and attached proposed amendments to Tribal Code, Chapter 30, Child Welfare Code. Be it further resolved that this resolution is effective immediately.
Okay, is there a motion?
Motion.
Motion by Hannah, support by Tyler. Ryan, could you explain this resolution, please?
Yes, this resolution would amend our Chapter 30, our Child Welfare Code, to expand a definition of abandoned to include when a parent is found to have abandoned a child for 2 years or more, that could be a basis for a risk of harm analysis or an analysis that would lead to a customary adoption or an adoption in our court or in state court. Also to add a definition for alienation, which would cover when a parent may be alienating that child and prohibiting that child from seeing the other parent, and if that could be substantiated in our court under our code, that would be an affirmative defense to stop a involuntary termination of that other parent's parental rights.
Okay, thank you, Ryan. And this stems from a case where a tribal family is trying to terminate the parental rights of the biological father who's non-tribal, which would open up the possibility of the stepfather legally adopting the child.
That's right. If this code change passes, it would also give our qualified expert witness in state court the tools to explain to the state court how this is viewed in our tribal court and through our code, which would allow potentially the state court to make different findings that could lead to an adoption or a termination of parental rights, where they can't currently.
Yeah, and in this situation, you have the non-tribal father hasn't seen the kid in like a decade. It's a rare case, but it's one of those situations where, the code that we currently have makes it difficult for the family to achieve the permanency that they desire. So have a board discussion if you guys want to have one. Aaron?
Yeah, my question is, what is the position of the tribal legal department, the ICWA attorney, the child welfare staff, and the child welfare committee?
It's a bit bifurcated, Aaron. My position is that if the board wants to go down this route to give a additional tool to our qualified expert witness, I believe this language is one of the best ways to do that. Our ICWA attorney thinks that this could open the door to potential legal challenges in the future or difficulties in our enforcement as a tribe of ICWA and MIFPA and potentially diminish our standing, and that aligns with Jamie Moran, our ACFS director's stance as well. Did that answer your question?
Yep.
Okay, anyone else? Rob?
Yeah, so I have a difficulty with this one because I see it both ways. I agree with the chairman in a lot of senses that I really don't have too much tolerance at all for fathers who abandon their children. And, I was lucky enough to be raised in 2 separate homes, but I had a loving mother and a loving father in both homes. I was primarily raised by a single dad who you would have literally had to kill him to get him away from his kids. So I was really blessed to be raised like that. So when it comes to parents not being involved in their kids, I just don't have much tolerance for it. But on the flip side, my views have changed a little bit in understanding since being on the Child Welfare Committee, where I have seen cases where one parent has made multiple cases actually, where parents have made some pretty egregious threats towards another parent that you can understand why they maybe haven't attempted to try that. When one parent's, I used to not even believe in alienation. I used to just say, well, if you're not willing to do that, then you probably don't deserve to have your kids. But when you have one parent that says, I'm going to say this, this, and this about you, if you ever try to see your kid, I mean, that's why we define alienation. I have a really hard time moving down this road this fast without allowing the committee to fully discuss it. But I do absolutely believe that we need to establish a process, a pathway for especially families like this one, because it is really heart-wrenching, and it should never be to this point where someone's able to not see their kid or make active efforts in 10 years. And the argument that there's no risk of harm is something I also don't buy at all. If we have one parent who has a loving stepdad and a mom and a solid home, they deserve permanency, absolutely. And then on the case, heaven forbid something happened to that parent who's responsible for that permanency, there's a potential that this child goes back to someone who's been violent. And not in their child's life at all. Honestly, I can't see even at this point why they're not agreeable to allowing their kid to have a permanent, loving home. I just don't understand that. But knowing the flip side of that is that we could be moving down the road of setting precedents. I'd have to give a lot of, grace and thought into what our committee has to say, what our staff has to say, and what our ICWA attorney has to say. I don't want to make a rash decision because I feel like I do for this family. I think this family absolutely deserves their permanency, but we need to be very careful about how we do that. We need to make sure that scope is extremely narrow. And there was some other options today, like providing a pathway to deal with this within our own court under a customary adoption policy, which I would want to go further down that road. But truthfully, I would like to sit down with the committee and really hash this out. I mean, it could end up being a 2, 3, 4 hour long conversation, but I just haven't heard all of the specific details. And knowing that we have, 400 or so more cases open at this time, I can't truthfully say how I would, if I know how this would affect all of them. So it's really hard for me right on this one, because on one hand, if I could just snap my fingers and have this child be in a permanent situation with the mom and stepdad she's in right now, I would. But making a long-term decision on behalf of our tribe that could affect many other cases where the situation just might not be the same. And so I have to be really careful on this one. And so that's where I'm at with it. I wish there was an easy answer.
Lana?
Yeah, well, we workshopped it this afternoon, and we workshopped it once, or maybe once before?
We've
Once
workshopped it
before.
with ACFS and the Child Welfare Committee,
Yeah.
yes.
And I know that it definitely is a hard one, because what happens within our tribe is we make code and we never look at it again and we never change it. And we just, whatever is put in place, we just go with it. And this is a prime example of it not working, in my opinion, for the families of our tribe. We've talked about a lot of different things. The last time we talked about it, there was some compelling information. And I do have the utmost respect for our Child Welfare Committee. I went to 2 meetings and I couldn't handle it and I didn't go back. So I know the in-depth decisions that they have to make, so I respect that, as well as our staff. It's a hard position to be in. But I think that by us putting a time frame in here at a 2-year, and the Child Welfare Committee and the judge still do in-depth decision-making in this. So it's not like if they're 2 years and they abandon the child, then we just give the child to the parent. It's not like that. There's still all those mechanisms in place. This is just one of the fluid things we can do to get better with the protection of our family units. And what I can stand on just simply is that, the risk of harm to the child is if, God forbid, something happens and this child is put to a stranger that they've never even been around. That is a child welfare issue. And it's ICWA, because that would take that child right out of the community, the culture, and be placed with a stranger. So I think that it's worth looking to see if we can change this code. If it doesn't work and something drastic happens, then fine. But when a tribal member, and people can call it for what they want, there is definitely unique situations, and that was stated last time and this time. There's unique situations. If it becomes that it doesn't work, but I can stand on that the Child Welfare Committee and the judge and all the players and the stakeholders still have the same decision-making and to prevent anything that goes awry. So, again, there is a risk to this child. As a mother, as a grandmother, I can't even fathom that my grandkids would go to somebody they have never, ever met. And I can easily say that, as a mother and a grandmother and a leader. So I'm going to stand on that.
Aaron?
So, all right, first of all, we've got to clarify that ICWA does not apply in custody battles between a tribal member and a non-tribal member biological parents. And in fact, if people who pay attention to this stuff at NARF or the National Congress of American Indians or the National Indian Child Welfare Association, we don't want sloppy cases to get into the court system. ICWA is not a shield to deny a non-native parent access to their child. And that's a mistake to interpret it that way. It's not what the law says. So let's make that part really clear. The other thing, and I said this earlier today, is, we have a drug court. And we recognize that people make mistakes. We recognize that people can make some really serious mistakes, but we also recognize that they can come back from those mistakes and they can recover, and they should have an opportunity to petition to get their child back, their biological child back. So unless we think that that should apply to Indian people and not to non-Indian people, the other thing is, what's the best interest of the child? Is it the best interest of the child to have their biological parent summarily dismissed from having access to custody, should they choose to do that somewhere down the road? And I have to say, no, I don't think, I mean, maybe I'm an example. I have a tribal mom, non-tribal father, and if he would have made effort to make access, I believe it would have been in my best interest for my biological father, who's non-native, to have access to be able to petition, to have, visitation or custody. The other thing is, we're talking way too much about specifics in a particular case. I think we violated the code left and right by talking specifics. The other thing we're doing by enacting a law that's specific to a case is we're enacting a bill or retainer law, which is we're writing a law specifically fashioned to affect an individual case. That's illegal. You can't do that in the U.S. Constitution, and we all take an oath to honor, and our Constitution says that we follow the U.S. Constitution. And the other thing is, so generally speaking, and that's the conversation we should have had on this, not talking specifics, but generally, if a tribal member has full custody, not shared custody, but full custody, and if a tribal member's non-native spouse has made no effort to gain access to the child, there is permanency. The mother in that situation, that hypothetical situation, the mother's custody is not threatened at all. And in a hypothetical situation, if a non-native person wants to adopt the child in that relationship, that's a good thing. I love that they would choose to do that, but are not consenting to that, or not even that, are not objecting to that in the court system, because we haven't filed anything in objection in any court systems. But in that circumstance, it would be wonderful, but that the child's permanency is not in any way in peril or challenged in that type of a circumstance. If the tribal mother has full custody, and the father is not involved in the situation, is not petitioning to be involved in the situation, permanency is not impacted. Permanency is established, it's not impacted. So I don't know why we're doing this, pulling on our emotions, and we're politicians. With the exception of Mike and Rob, who have served on the Child Welfare Committee, we're not even trained or acculturated or acclimated to the work.
I am, Aaron.
Okay.
I've worked on 3 reservations.
Okay.
Done this thing. I'm a master's level social worker. I absolutely am trained.
Okay. But our staff have recommended against this specifically. So why do we have a Child Welfare Committee? Why do we have a staff? And in the real review of all of this, because I had the feeling throughout all of this that somehow our staff was screwing up, that they're doing something wrong, that they're petitioning to try to damage somebody's family sanctity. And that is wrong. That's not happening. I find that egregious that characterization is being made. Our staff are not doing that. Our staff are simply not conceding to a petition in a court system because our law doesn't allow that. So I don't think that there's a problem that we're supposed to be fixing right now. And I said this to the staff earlier today. They're not without fault. They make errors sometimes, but I think we should respect our staff, because what are we doing if we're overriding the decisions of staff from a political table and I do apologize, there are other people that have that experience, but I don't have that direct experience. I've had foster kids, and I'm have a permanent placement, so I do kind of understand it. I do understand ICWA probably at a really high level, but I don't think there's a problem here that we need to fix. There's no permanency that's threatened, and so I just pulling on our heartstrings and politicians making decisions. That's what I see. So
Okay, so the list I have is Kimley, Tyler, anyone else at this point? And then I'm going to speak at the end of this, because I do have expertise on this and I can talk about the issue. So I have Kimley, Tyler, Rob, anyone else? Okay, all right, go ahead, Kim.
I guess it is my opinion that there's a lot of life-changing laws that happen because of a parent's fight for their children. That is in a lot of different areas. And I think by amending and changing this, that we still, between the committee and the judge, still has to make those decisions on a case-by-case basis. So, I mean, nope, I have not been on the Child Welfare Committee. I have seen enough in my lifetime that I can say that I've had plenty of experience. And in my own personal opinion, grief from a parent who comes in and out of a child's life or alienates a child is worse than a parent passing away, because they deal with that over and over and over and over again. So if they come after 2 years, if they come after 4 years, and they keep letting that kid down, I mean, I had my own kids' experience, and they've walked away themselves, every single one of them, because of the strength that was shown on the other side of that. So, I'm sorry, I think that that risk of harm is very, very great. So I will support this, and then based on the committee and the judge's recommendations, we'll go from there, because I also support them. So that's all.
Okay, Tyler.
Yeah, I'm not going to belabor this. I agree. I'm going to support this based on all the information that we were given. And while we're just politicians, we also are charged with creating the law and code that our tribe follows. And Mr. Chair, based on your input and feedback, which I'm basically going to just cede my time so you can explain this a little bit better, because you're the expert in this field. I trust in your judgment and everything that you've said. I've weighed both sides to this, and I agree that right now we need a code change for this family. There's a lot more to it. I can't go into detail because we shouldn't be going into any more detail. But we do write the laws, the codes that our tribe then must follow, and we do have to weigh that out. And I weighed it out based on your professional expertise. Thanks.
Okay, so yielding to me, I can provide some background information. So this tribal family is not opposed to us discussing this. This tribal family has attended workshops where they've talked about this, and this tribal family was willing to talk about this in open session. I put them in closed session, so it's not a matter of confidentiality. We have their permission. This isn't a matter of, okay, well, we're creating a code change to, help a family out that's not illegal. I mean, we examine how codes can better serve our members all the time. So you have a situation right now where a tribal member had a kid about 10 years ago with a non-tribal member. Shortly after that child was born, the biological father left. That biological father hasn't had contact with that kid since then. It's been about 10 years. So the biological mother petitioned the court to terminate his rights so her husband, who has raised that kid for approximately the last 10 years, can legally adopt the kid. So if this wasn't a native child, ICWA wouldn't apply, and the biological father's rights would be terminated due to abandonment. However, due to this being an ICWA case, because the child is Native American, you have all sorts of standards that have to be met. And it's basically because historically, Native American children were removed from Native American homes, placed in non-native settings where they then, were disconnected from their culture. So even though this is an ICWA type of case, it's not about the spirit of ICWA. This isn't a situation where a Native American kid is going to be placed in a non-native setting. On the contrary, the kid is currently living with the tribal member in this family. It's a biological father who's not tribal member. So the risk of harm is the biological father's parental rights are still intact. So a biological mother who's a tribal member gets in a car accident, the possibility of that child being placed with the biological father, even though he hasn't seen that child since that child's been an infant, is there. I mean, we see cases like that happen all the time. I've worked child welfare for the state of Montana on the Flathead Indian Reservation, for ACFS, for Bay Mills, it happens. Sometimes kids are placed with non-offending parents, if there is a child welfare case, or, you know, in the death of a family member, sometimes they're placed there without a treatment plan, sometimes they're placed with a treatment plan. So that's the risk of harm. But just imagine for a second, if you had a kid and 10 years goes by and you haven't seen that biological father, and there's been a wonderful partner in your life that's raised that kid for the last 10 years, and biological father wants nothing to do with that kid, biological father's not attending court, biological father has an attorney that's literally advocating for an empty chair in court next to them because they have no interest in going to court. Imagine how mad you would be if your tribe was opposed to that termination so permanency could be achieved by that step-parent adopting your kid. You know what I mean? You would be pretty upset, and that's the situation we have. It's not the fault of staff. It's not ACFS's fault. Let's lay that out. No one is saying that they're at fault. All they have is the code that's available to them right now. And right now, Chapter 30 does not list abandonment as criteria for termination because you have to have imminent risk of harm. All this does is give the Child Welfare Committee that tool to consider abandonment, risk of harm. So we've also amended the code to include parental alienation, because if a biological parent keeps a kid from another parent, is that really abandonment? That was kind of our compromise, so that can't happen. But I mean, if you're a deadbeat father and you haven't seen your kids for 10 years, you shouldn't use your child's tribal status to prevent a termination of your rights from taking place, so the man that's taking care of that kid can become that kid's legal parent. Period. That's how I feel about it. I mean, this isn't a common case, so this isn't likely to happen all the time, and I think that the assumption that this is going to cause long-reaching side effects is a reach, because at the end of the day, the Child Welfare Committee is still going to make the recommendation about whether or not they're going to terminate or reunify, period. And I have faith in that body. I have faith in that body even with this amendment. I don't think that they're just going to automatically apply it to everyone. The people on that committee possess common sense, they're smart, and also there's judges on cases. And also, you know, parents, in the case of this one especially, are given lawyers who can advocate for them. And if parental alienation has been taking place, they can argue that. But, I mean, it's a code change. If it creates problems, we can change it back, but I'm willing to give it a try, period. So that's the backstory. We have the family's permission to share it. It's not a typical situation. ACFS isn't at fault. Child Welfare Committee isn't at fault either. But this code change provides them with the tools to potentially provide the permanency that certain tribal families in situations like this are desiring. That's all. So let's get back to the speakers list. I have Rob, and then do I have anyone else? Okay, Rob.
I pretty much said everything I have to say. I just wanted to address a couple things because it was stated that there's no risk to permanency here, and there absolutely is. I'm not trying to hold this up at all because I don't believe that we should have a code for this. I absolutely do. I think that, you know, the reason we changed laws and the reason that we address codes is because situations come up that flag things to us that needs to be changed. I 100% believe that this needs to be addressed, and our Child Welfare Committee needs a pathway to do it. My holdup is that the committee hasn't had proper time to discuss it. The ICWA attorney's not comfortable with it, and ACFS isn't comfortable with it. And I think that we need to be very careful when we're talking about setting a precedence, because yes, we could change our codes back and forth based on the outcome of it. We're not going to change case law. We're not. And if we go down the road of this, remember the flip side could be that a non-native parent could be trying to terminate the rights of a native parent, and unless you're sitting on that committee, you don't fully understand or know what was done between those two. And like I said, I think we need to be very careful and narrow the scope here. But at the same time, like I said, if I could snap my fingers and have this be permanent, because, you know, another thing was said earlier that there's a potential that, you know, if this, in this situation, if the non-tribal parents' rights are terminated, and then the person who assumes the adoption would then have rights, well, what if they get divorced or something, and then that you're going to have a non-native stepdad who has rights, and my answer to that is good, because when you are a step-parent and you raise children as your own, they are yours. And probably the worst pain anyone can feel is raising kids for years that aren't yours, and then having no rights when the relationship ends. And I don't believe in that either. I believe that if you're a good enough person to assume the responsibilities as a parent for years, then you should have those rights. And if this mom believes in that, her partner enough to go through with the adoption and make that available, then that parent should have rights. That's not stepdad, that's just dad. You know, dad, like in a case like this, dad's long gone, and I really believe that we should have an avenue for us to address situations like this and to establish the permanency. But there is a risk to permanency. The risk is the permanency is depending on the mom's health. And, you know, heaven forbid something happens, we're essentially supporting codes that would give that child back to a parent who's potentially dangerous and has zero relationship with that child when the child has a dad. So I think we need to do something. I'm just hesitant to do it quick without having our ICWA attorney, Child Welfare Committee, and ACFF staff say, yes, we're comfortable with this, because there are options and we could go through them. So that's where I'm at. I wish there was an easy answer. I wish it was quick and easy and we could do what's right for this family and also every family that comes after it in the same situation. But then again, remember, we're literally responsible for thousands of cases, and that's not an understatement. That's just the reality of it. You know, there's at any given time you could have 400 or 500 cases. Now times that by 50 years that we've been a tribe, you're literally talking about thousands of cases. And so this might be rare, but no matter how rare it is, we have to have an avenue to address it, because this isn't right either. I mean, we have to do what's right by these families. I just want to be really careful and do it in the best way possible to make our staff that has to deal with it on a daily basis also comfortable with it, so we know we could provide protections if this wasn't the specific case. Are we opening up case law to go down a different road? And I just don't think we spent enough time on it.
Okay, I appreciate it, Rob. That's your second turn. Aaron, this will be your second turn as well.
Okay, so when we talked about this afternoon, was this in an open workshop? Okay, so and the example that I used was, because I'm worried about the unintended consequences here, because, you know, making decisions based on emotion and a slipshod sort of approach and then trying to clean up the consequences later, we talked about whether or not this would afford a non-native some kind of authority within our court system. And, you know, we do already have an example of that, and I see Maria over there, so she'll recognize this, but they're not empowered to do anything about it. In housing, if you add somebody else to the lease, like I know of a situation where a mom was in a relationship with somebody who molested her child, the person got indicted, and the person who was the perpetrator refused to leave the house because he was on a lease. The mom and her little kids had to get out of that house to protect that child, and it's because he was on the lease. So we shouldn't be about enacting laws that will give non-natives some kind of additional authority within our court system that is an unintended consequence. Here's the other thing, okay?
Can I add something to that, Aaron? I don't think it will do that, because this case isn't in our court, it's in Mackinac County, and I know we're not doing this for case-specific reasons, but as you've already mentioned, if a case ends up in tribal court, ICWA doesn't apply, so you don't have to prove that imminent risk of harm. I don't think this code change will do anything in our court to give anyone who's non-tribal extra authority or anything in our court.
And so I may be on the losing side of this argument, and, you know, I'll probably be portrayed as, you know, somebody that's trying to give rights to white people or something, but a child's interests are distinct and separate from both parents. Both parents, typically the way we see property rights, basically child welfare is interpreted like property rights. and a child being perceived as a commodity or a property. But the child's rights are independent of either parent. I've done some research on this. In my doctoral program, I did a lot of focus and education on this. And the child's rights are distinct and separate from both parents. And here's the thing. So sometimes we have this illusion at the tribal board level that we can enact laws that just completely ignore federal law. You can pass this, but it isn't going to make a hill of beans of difference. If a tribal parent passes away, there's nothing we can do to shield the federal custody. ICWA does not intervene to protect a tribal child from having access to their biological parent. If the mom were to die, the court has to notify the biological parent and give the biological parent a right to take custody, because it's their child. And whatever our opinions are about any particular case, you know, and I have to admit, everything that I've heard looks pretty bad, but if a tribal family, a tribal parent dies, the court systems will petition, and the biological father has to be notified and will get the opportunity to take custody. And ICWA does not protect against placing custody with with another Indian family. ICWA applies when the biological parent never shows up or doesn't contest or whatever. Then we apply ICWA to try to, or courts apply ICWA to find an appropriate tribal placement. So we can do whatever we think we're going to do here today, but it isn't going to change the fact that a biological parent still has legal rights outside of, you know, anything we think that we can enact. So that's it.
But here's the thing, Aaron, and you spoke twice, so I'm just going to say what I'm going to say. You're right about ICWA, but if you don't have any parental rights because your rights have been terminated in state court, even in the event of a death, it's no longer a custody issue because you don't have legal rights. That's what they're trying to do. That's the very reason why they're trying to do this. It's because those legal rights exist, and ICWA can't protect from native to non-native. That's why they're doing it. Okay. All right, we ready to roll call, guys?
I actually want a motion to refer to committee for 60 days and give them 60 days that they need to come back to us with recommendations.
Okay, so we have a motion and support to table this. So as you guys know.
No, not table. I don't want to table it. I want a solution. This cannot go on. We need to find a solution for this situation. But I would like to refer to committee with a 60-day time frame that the committee meets with their ICWA attorney and bring us back recommendations that makes sense.
But you guys are aware that this family has a termination hearing coming up, and they would prefer the Child Welfare Committee to review their case with this potential code change. That way they can have a potentially different outcome. So you guys can cast your votes however you want to, but I'm letting you guys know that as well. So we have a motion to refer it to the Child Welfare Committee to have a proposed solution in 60 days. It's also worth noting that we did workshop this with the Child Welfare Committee as well. So twice. So we'll roll call this.
This is the motion to refer to the committee for 60, and have them come back with recommendations in 60 days. Kimberly Gravel.
Yes.
Aaron.
Yes.
Tyler.
No.
Bridget.
Yes.
Isaac.
No.
Lana.
No.
Rob.
Yes.
Kimberly Lee.
No.
Kimberly Hampton.
No.
Larry.
No.
6 noes for you.
Okay, motion to table or refer fails. So we're back on the main resolution. So if you guys have spoken twice, please keep your hand down. Any more comments from anyone who hasn't spoken twice? Okay, Isaac.
I don't know if, I'm really tied. It's confusing. I understand it all, but my concern is always about the child, right? So if this gets turned down, the child's gonna be in limbo. But if we do approve it, right, the code change, then we don't know how that's gonna affect any future children. So I'm stuck in the middle here. I really am, so I don't know how I'm gonna vote.
Anyone else? Okay, last thing I'll say is, you know, as a social worker who has worked in child welfare, you know, we operate based on best interest of the child. And there are situations when maltreatment is occurring where the parents don't place the best interest of the child at heart. But I don't believe this is one of those situations. I believe in this situation, the biological mother knows the best interest of the child, and that's why they're trying to do this. And if I was in her situation, I would do the same thing, and I would be equally frustrated and upset at the way this has been handled. So let's roll call this.
Tyler.
Yes.
Kimberly Gravel.
No.
Lana.
Yes.
Isaac.
Abstain.
Larry.
Yes.
Kimberly Lee.
Yes.
Rob.
No.
Aaron.
No.
Bridget.
No.
Kimberly Hampton.
Yes.
5 yeses, 4 noes, 1 abstention.
All right, motion carries. All right, the last resolution that's on for tonight is the one that we waived the rules to add. It is Wells Fargo Enterprise Housing Affordability Breakthrough Challenge.
Now therefore it be resolved that the Board of Directors hereby authorizes and approves the Sioux Tribe Housing Authority Director or their designee to execute any and all documents as may be necessary and appropriate to carry out the terms, conditions, and intent of this resolution.
Motion. Support.
Motion by Isaac, support by Larry. Maria, could you explain this for our membership, please?
Good evening, Maria Monjean, Housing Director. This is a $2 million grant that we'd like to apply for. It's through Wells Fargo's and Enterprise, and the purpose of the grant is to expand access to quality, affordable housing through innovative challenge encompassing designs, construction, finance, and service delivery, and program focus. So we feel that this would go in line right away with our supportive housing project.
Okay, I appreciate it, Maria. Any questions or comments from the board? Okay, hearing none, let's do a roll call due to the amount of this if we receive it.
Kimberly Hampton.
Yes.
Tyler.
Yes.
Rob.
Yes.
Kimberly Lee.
Yes.
Isaac.
Yes.
Lana.
Yes.
Larry.
Yes.
Bridget.
Yes.
Kimberly Gravel.
Yes.
Aaron.
Yes.
Okay, motion carries. That concludes all the resolutions for this evening, so we're moving to new business. Any objections to me handling committee appointments / resignations as a whole? Okay, hearing no objections, we'll handle that as a whole. So I would like to entertain a motion to appoint Walter Caswell to the Elder Subcommittee, Unit 2, Newberry, to accept the resignation of Sandy Alsterhout from the Elder Subcommittee, Unit 2, Newberry, to accept the resignation of Harold Osterhout, Elder Subcommittee, Unit 2, and accept the appointment of Suzanne Codwell to the Health Board.
Motion.
Motion from Lana, support by
Isaac?
Isaac. Any discussion on these? Okay, hearing none, those in support signify by saying aye.
Aye.
Those opposed? Those abstaining, motion carries.
You abstain?
Yep, Bridget abstains. That brings us to the final item for this evening, which are board concerns. If you guys have them, pass them over. If you guys want to talk about yours, raise your hand. Okay, Aaron.
All right, I'm not going to go through all of mine, but, and I always type mine up ahead of time. So, first of all, I will co-sponsor the 3-branch separation of powers. We didn't have the votes to suspend to do that tonight. We fell short by 2, but I think we will have the votes at the meeting. So I'm going to co-sponsor that. I do have a question for legal, and whether you can answer it tonight or just do a response, but, you know, as a fiduciary body over our tribe's assets, we're the only body that is. Our independent auditor, you know, routinely every year submits and asks if any board members have any concerns that they want to share with the audit. I was advised that I needed board approval to talk to the auditor about any concerns I might have, but I don't recall ever any board members ever having to get approval by the board of directors to share issues with the auditor. So I'm requesting to know what the federal accounting law is on this. I was going to meet with the internal auditor, or the auditor, yesterday, but I held off because I want to ask this question. I don't want to do something that's going to get me removed from office. But I need to know what the law is. I do have a time scheduled later this week to meet with the auditor. It's a normal process of audits where they ask the fiduciary if they have any issues or concerns they want to bring forward. That's how you do an audit. If we're stifling access to talk to the auditor, I think that's probably illegal. Not only is it not legal, it's illegal. So I'm asking for that later, not tonight. So I also want to bring forward, I've heard a lot of hullabaloo about, well, bring issues forward. So there was an allegation years ago of a $330,000 expense for personal bankruptcy, not related to the tribe. Tribal Legal investigated it, so I'm asking if we can pull out that investigation so the board can see it, because I think most of the board members here were not here then. And then I would like to, once we get a copy of it, I'm going to make a motion to make that public so that the people can see what the results of that were. Notice I didn't say what the results of it were just now. I have seen it, but I'd like the members to see the results and to see what the board did about it or didn't do about it, or what the board could do about it. $330,000 is a lot of money to leave our coffers, and if I recall correctly, it was in checks cut under $50,000, so the board wouldn't even know about it. So we can't be complicit. We can't sit back and wash our hands of it and say it happened a long time ago. It's our responsibility. So, all right, number 3. All right, so this morning, I saw a copy of the budget sheet that goes attached to our actions at the gaming authority level, posted on social media, and it had handwriting on it, and it shared details of a closed and confidential document all over the social media. Somebody sent me a copy of it, and then I had to go and find it for myself, and I did see it. I'll share with legal on what site I saw that on. Somebody's handwriting's on it, which means somebody's kind of stupid, because if they posted something that only this board has access to, and their handwriting is on it, that's a removable offense. So I want to know what's going to be done about it, and whether I can post it. Can I take a copy of it now and post it and ask online, hey, can anybody tell me whose handwriting this is? Because I'm getting a little tired of bringing stuff to this table and handing stuff off to legal or to the prosecutor's office, and nothing happens. I know if I would have done something like that, if that were my handwriting, I would be investigated, I would be removed. And that is why I always turn over all of my documents to get shredded, so I don't take any documents home. But to be very clear to the membership listening, somebody who attended the Gaming Authority meeting, only the Board of Directors has copies of the attachments, the IRS and the attachments. Somebody from this board hand wrote on that document, and that's the document that's circulating all over the internet right now. So something needs to be done about it. So, and it's not the BIA funding, it's tribal funding, so I can't do a whistleblower and call the BIA and tell them, but something needs to be done about it. It's serious. Somebody is breaching confidentiality openly, and there needs to be a consequence about it. So, and if you're not that person, then you should support trying to get to the bottom of it and holding that person accountable. Thank you.
Okay, thank you. Does anyone else have any
Austin,
board concerns?
can I respond to a couple of things quick on that?
Yeah.
One, for the audit thing, I apologize, Director Payment, maybe we got our wires crossed, but I think Holly and I both answered that question via an email that we have no problem with you talking to the internal auditors. Previously, our practice was you just let the audit committee chair know, hey, I'm going to go meet on this day with the auditors, and they set it up. So I know we initially had an email back and forth, and I didn't know what our internal process was, but conferred with Holly, and I'll send you the email again if you need it, but we don't have any problem with you meeting with them.
Okay, thank you. There's no federal law that I'm breaching, or tribal law?
Not that I'm aware of.
Okay,
Correct.
thank you.
Correct. For the unauthorized release of information, it is a violation of our open meeting ordinance, and it is punishable by a resolution of censure by the board if they want to bring a resolution to censor a fellow board member for releasing confidential information, maybe arguably also removable offense, right? It's a breaking our law. I'm aware of what got posted. Josh and I were looking at it this morning. I don't know who posted it or who the handwritten notes are from at this point. But those are your two remedies right now, right, under our current code. As far as, Director Payman, if you wanted to post it, unless the board tonight authorizes you to release that, you would also be in violation of releasing it, so I wouldn't
Okay,
advise
that's all you
doing
have to
that.
say.
So, time out. Ryan, is it your legal opinion that what was posted is confidential information due to the proprietary nature of what was written on it?
Yes, I advised at that meeting not to post, not to put all that in the resolution, and that backup documentation was proprietary, so the fact that it's now out there in the wild is a violation of our law.
Okay, I won't be posting it.
Yeah. I still want you to also be, violating the law, just because someone else did, so.
Okay, thank you.
Okay, does anyone else have any board concerns for this evening?
And my shredding's
Okay.
going that way.
So without objection, then meeting adjourned? Then here, single objection, so meeting adjourned. See you guys tomorrow or next Tuesday, whatever you guys attend.